Court, all rise, please. Here, all persons having anything to do with fully honorable. The justices of the appeals court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to this sitting of the Massachusetts Appeals Court. My name is Justice Wolohojian, and it is my great pleasure to be sitting today with Justices Desmond and Sachs. We have a very full list of 6 cases this morning. I anticipate that we'll hear the first 3 and then take a morning break. With the exception of of 2 cases where specific orders were entered as to how much time or whether people will be permitted to argue, each side will receive 15 minutes to argue, and there's no rebuttal in the appellate courts of Massachusetts, so don't reserve time for rebuttal. You may assume that the panel has read not only your briefs, but large portions of the record. So you do not need to use your time to educate us on the background facts. Of course, you are free to structure your argument in any way you wish. I just want to let you know that you don't need to feel like you need to give us all the background. With that, and I should just tell you a note about our time system. The yellow light goes on 1.5 minutes from the end of your argument time to give you a sense that you may want to start thinking about how you're going to wrap up your argument. And the red light goes off at the end of your argument time, and unless we have further questions, you will need to stop. The clerk will set the time for each argument according to what we know you've reserved for the multi-party case, okay? So so I'll try to keep an eye out to make sure that's correct too. All right, with that, and I think it's only the first case. Well, no, we've got some. All right, the first case is impounded. So we will all try to remember to use not the parties' names, but maybe some common set of designations. How about mother, father, oldest child, and twins? Or if you need to separate out the twins, which you may, I don't know, but something other than their names. All right? I think we've got, well, I have multiple names on your side of the V, so I don't know who is arguing first. Would you please tell me who you are and how your side, the order of argument, and how much time each person's
Good morning. My name is Laura Openshaw. I represent the appellant mother in this case. Does the court wish for me to explain who will be arguing after me?
Who's going to argue in which order?
Following me will be Attorney Laura Krismer, who will be arguing on behalf of the younger children. Following Attorney Krismer will be Attorney Dow, who will be arguing on behalf of the appellant father. And then last will be arguing Attorney Laura Boulian, who will be arguing on behalf of the appellant oldest child.
Okay. Let me make sure I have that right. Okay, Attorney Openshaw, and you've each reserved 5 minutes for each, correct?
Sure.
Very well. We're ready whenever you are.
Good morning, members of the panel, and may it please the court. My name is Laura Openshaw, and I'm representing the appellant mother. I'll start by saying that the parents and the oldest child are joining us by YouTube this morning. In the 2.5 years after the 3 children were taken from their parents, the mother engaged in every recommended service, and even her DCF caseworkers acknowledged the change in her life, her home, and her relationships. Despite this uncontested evidence, the juvenile court concluded that the younger children's needs were so significant and the mother's ability to parent them so limited that the mother would never be able to adequately meet the younger children's needs, and this was error. In so doing, the juvenile court relied on, overstated the younger children's needs and understated the mother's ability to parent them by relying on stale evidence, improper inferences from the evidence, as well as clearly erroneous findings.
May I stop you on the stale evidence idea, please? So what do we do? How are we supposed to think about the fact that time passes when children are out of the care of parents? And I'm just going to give you an analogy of what I'm thinking about. Someone argues, well, I didn't commit any crimes in the last 2 years. And during the last 2 years, that person was incarcerated. So, you know, in some sense, I struggle with the idea of what does that then indicate, that they didn't commit any crimes at a time when they weren't actually able to commit any crimes. And I am not trying to suggest that the mother was committing crimes or anything like that. I'm just saying that we have a period of time when the children are not in the parents' custody, and the parents, on this record, it appears to me, are able to function in a better way, let's just say. How is it that why is it then that the evidence of what happened when the children were in the parents' custody becomes stale simply by the passage of time? Does it have no bearing on the assessment of fitness? Does it have some bearing? Can the judge decide what bearing it might have?
Your Honor, I think the way to think about this is thinking about what changed between 2019, when all 3 children were in the home, and the period after the removal of all 3 children in September 2019. And what happened between 2019 and the trial was that the mother and both parents engaged in a lot of services, and that was exactly what they were supposed to do. This was in many ways a success story, that these were parents, especially and I will speak to the mother in particular, who did everything DCF asked them to do, where third parties, including a family therapist, including the mother's substance use clinician, and including 2 different DCF social workers, said both, yes, they did everything, and yes, what we were looking for happened, which is that the mother actually made change.
She got arrested for shoplifting, is that right? What year was that?
That was in January 2020. So
That was after the kids had been removed.
that was after the kids were removed.
That clearly wasn't on the action plan, right? I mean, that was clearly one of the things she wasn't supposed to do.
To engage in criminal activity. That's correct. There was no evidence of any criminal activity by the mother, and certainly not shoplifting after January 2020. It's also worth noting that that was weeks, maybe less than a month after she became sober, that there was no evidence in the record, nor is there any suggestion by the department or even in the court's findings, the trial court's findings, that the mother engaged in any form of substance use, including alcohol use, after what she testified was her sober date. And she got there by engaging in a number of services that are in the trial court's findings at 141, 141A, and I believe 145, including medication-assisted treatment, including counseling. And there's no suggestion, returning to Justice Wolohojian's question, that there was on the one hand, there was no suggestion that there was activity going on behind the scenes, whether that's domestic violence, whether that's substance use. Nobody suggested that was the case. And the way that they got there was by engaging the treatment that was designed to get them there.
Right. So, but the way I understand your argument, though, is the court required to sort of engage in an experimentation where the children are returned to see if and then have this, to see whether the parents can operate when there's evidence that when the children were there before, they couldn't? Do you see what I'm saying? How many times, if we don't look at this from the perspective of the mother or the father, but from the best interests of the children, are the children to be just returned when the parents were previously, I mean, I think we could probably all agree that at the moment that the children were removed, the judge could have found that the parents were unfit. So, so is the judge required to return them just because over the subsequent period of time, the parents were able to make strides? That's my question.
This is a case where the parents did the best with the opportunities they were given. This was a case where the parents had actually had filed a motion for an increase in parenting time with the children. And in other cases where there's not a goal change to adoption, often what happens is that parents who are doing well in services are given longer and longer periods of time to parent their children with less and less supervision and structure, basically to try to transition and for the parents to be able to demonstrate that they can or cannot independently care for the children, that they can demonstrate not just that they did the services they were asked to do and they said the things that they were supposed to say, but that they're able to put those things into practice. And they did the best with the opportunities that were given them. This was a case, though, where DCF didn't suggest any domestic violence services, for example, where DCF didn't give the parents opportunities to engage in services relating to the younger children's needs, such as they were. But where the mother and the father also engaged in the services and with what they had. If there's
We're going to have to leave it there unless there are further questions. No, thank you very much.
Thank you.
Is it Attorney Krismer?
Good morning. May it please the court, Laura Krismer, and I'm for child 2 and 3, and I'll refer to them largely as the girls, or possibly the twins. And I just want to say at the outset that the girls have had the position that they want to return home to their parents from the outset of this case. Although they were age 7 at the termination trial and are now age 8, and so it's not statutorily mandated, under adoption of Nancy, the SJC has clearly indicated that a judge should consider children's expressed interest and that it should be given weight. And what I'm suggesting to the court, both in my brief and today in argument briefly, is that that was not given weight. I think that the place that is most clear, where you can see this most clearly, is if you look at conclusion of law number 24 and 28. With regard to 24, the judge says, as to the girls, the parents' failure to follow through with services for the brother when he was reunited with them in 2019 shows that it's unlikely the parents would be vigilant for services as to the girls. And then just 4 conclusions later, with regard to the brother, she indicates that the mother has shown consistent participation in services and demonstrated progress towards fitness. So when you look at those two and you're balancing best interests, and this goes a little bit to the staleness argument, certainly I would suggest that the situation that occurred in 2019 is a historical fact. It's a fact that we can't really do much with. The issue is whether the parents are able to use the services and show progress. And I would just direct the court's attention to the testimony of the therapist, the brother's therapist. And she indicates very clearly, she's worked with this family on a weekly basis for a number of years. She indicates that the parents learned from their mistakes, they were able to apply new skills, they gained insight into actions, how their actions impacted the children, and they were able to apply new skills. So that's current evidence of their fitness. And it also goes to the children's best interest, because if the parents have learned that skill with the brother, arguably they're going to be able to apply that skill to the girls. And in that regard, I just want to point out in terms of the record that there was only evidence that the young child K had an IEP. There was no evidence regarding the other girl R. The other place that I would direct the court's...
You say there was no evidence that
of the IEP.
R had a IEP.
Yeah, I apologize. I missed that. I forgot the rest of that sentence. The other place that I would direct the court's attention to is the bonding expert, because when the judge assessed in terms of best interest the testimony of the bonding expert, she basically kind of manipulated the testimony to support that it was in the best interest to terminate the parents' rights because there would be some trauma to the girls. The judge, I would suggest, went further and shifted the burden to the parents by saying that the parents didn't show any evidence. That's faulty for two reasons. One is that they did. Dr. Duran clearly testified that the parents had, in fact, considered that it would be traumatic for the girls to entirely lose their relationship with their foster family, and that they had, in fact, considered that and would maintain a relationship. And there was lots of evidence in the record that these two families do have some kind of a relationship. But she didn't engage in that same analysis in terms of whether the department had, under Catherine, considered and found inadequate.
Let's say we were to agree with some, well, let's just say you, the appellant. What would be the relief? It seems to me there's been a whole additional year.
Yes.
And I suppose what would happen is the matter would be remanded, and there would have to be another trial to assess the parents' fitness at this point?
No, what I would...
Because the way I understand your argument is that it's always a moving target based on the date of the assessment of fitness or unfitness. So why wouldn't that be what would happen? And at the same time, we've had another year where these children have been in their current placement, and I mean, it doesn't sound like it sounds like it's a good placement. So can you help me understand that even if you prevailed, what would be the relief?
The relief that we would be asking for is to vacate the termination decrees and remand to the court with an order for progressive return home of the children, that it was specifically that it was not in the girls' best interest to terminate their parents' rights as to them. And then what this court would leave open to the trial court would be how that progressive return home
We
could
ever
occur.
done that in a DCF case?
Say that again?
Have we ever done that in a DCF case?
I will have to get back to you about that specifically.
Okay, and then I have another, sorry,
ahead.
go ahead.
Nope.
I have another question for you. What is the current state of sibling visitation?
The current state of sibling visitation is that the girls, I met with them on Tuesday, they are having remote contact with their brother, and then they are having some in-person visitation with the brother and the parents, because the brother is now with the parents and the case with him has been dismissed, so that when they see their brother, they are also seeing their parents. But it is only every other month at this point. I did want to just briefly address the issue of parent-child visitation. What I would suggest to the court is in terms of that order, and this kind of relates to the last question that you had, the order is sufficiently vague. It doesn't address the frequency, time, and duration. So just to walk through what would happen.
Right, we have your brief on this,
Okay.
and you're out of time, so let me see if there are any further
Thank you.
questions.
You indicated that you think the relief would be to vacate the termination, is that right?
Yes,
And the finding of unfitness?
yes, yes. Thank you.
Wait, hold on, let me see. Thank you. Is it Attorney Frizzoli? Or no, Attorney Bouillon?
Attorney Dow.
Okay, I got it wrong on, oh, sorry. I'm so sorry. And are you representing the father? So sorry.
It's okay.
We're ready. We're ready whenever you are.
Good morning. Attorney Deborah Dow, and I represent the father in this case. Just a few responses to Your Honor's questions. As far as a timeline for stale evidence, I would just direct the court's attention to adoption of Ramona, adoption of Rona. Those cases really do stand for the proposition that it's DCF's burden, and the burden is current fitness, and the focus should be on the present, not on the past. In addition to that, as far as a remand and a vacating of the orders, the department, again, would have the burden at that point in time of showing or proving by clear and convincing evidence that the parents were unfit with respect to the twins. And most likely, there would be a request for a dismissal and/or a reunification plan. I think that would probably be the focus.
There seemed to be some concern about the supervision of the children and the parent's ability to supervise them, given the injuries that the oldest child suffered and one of the twins, fairly significant injuries. What in the record do we have that says they now are able to supervise, given they have had no opportunity to do it in the last year or so?
There isn't much testimony with respect to that, because the department had taken the position that they could not modify the visitation during the course of the trial, despite the recommendations of their own independent foster care review panel. So I admit that there isn't much information. What we do have is, at the beginning of the case, or relatively near the beginning of the case, the parents were having extended visits with the children, and there were no issues, no concerns.
Supervised visits?
I believe that they were loosely supervised visits, and this was pre-pandemic. And again, because this case ran the course of the pandemic, I think there were some modifications that maybe didn't provide some of those opportunities, in addition to DCF saying that they could not or would not provide those opportunities. But the parents did the work here. Father absolutely did the work. He had therapy throughout. I think that there was testimony and evidence that he responded well to the children. He engaged in therapy with the oldest. He came to really understand what their needs were, and so he was better able to interact and better able to communicate. And so because of that, he was responsive as far as what they were going through and what they were coping with. And from his perspective, he even got to the point where he was able to make a recommendation or suggestions in noticing how upset the girls were when they were placed in a second or even third respite and came back so upset, requesting that additional therapy be provided to them. So I think that the parents came a long way in doing the work to be able to have this unsupervised contact. Unfortunately, it did not come to fruition to the extent that we would be able to say, well, see here, this was successful. But certainly, they got to the point where they were able to, have a very strong understanding of the girls' needs, emotions, schooling, all those things combined.
Both parents, at one point or another, suffered from some substance abuse issues, albeit alcohol or Adderall or whatever it may have been. And certainly poverty was an issue confronting this family, for sure. What are we supposed to take, or should we take anything from the fact that parents have now seemingly begun to engage in gambling, faced with poverty and substance abuse issues, are now seemingly spending time at Encore and engaging in that type of behavior? Is that appropriate for us to consider, or does that impact their ability to care or provide the appropriate needs for their children?
So I think that there was one incident where the parents had gambled, and they had some, it sounded like free, from what I could get from the testimony, free paraphernalia from Encore. And so that was noted. It was noted by the judge as well. But as far as we know, it was only one incident, and there was never anything that was testified to in addition to that. and I believe that dated back to 2020 as well. So again, I think that these parents, and there was no indication as to lack of sobriety, and as far as the gambling, whether or not that there was an actual nexus between that one incident that was testified to and potential harm to the twins in this case.
Is there recent evidence in the record about the parents' ability to maintain a stable home environment? I mean, I think they're in a 3-room apartment, and employment that would bear on whether the one incident of gambling you mentioned is a problem in terms of their finances?
The parents are in stable housing. They got to the point where there were no concerns about cleanliness of the home and stability of the home. And in fact, that portion of the task was actually taken off the action plan. I think there was also testimony that father was more gainfully employed in a position that was a 7 a.m. to 7 p.m. Type of job. And so the housing stability issue seemed to be resolved by the end of the case, by, I think, a year before the end of the case.
Where is that testimony about the father's employment, if you know?
I'm sorry, about the
Where,
what?
about the father's employment? Or if there's a finding about it?
Your Honor, I would have to look at that, but I know that there was, that he provided testimony that he did work 7 a.m. to 7 p.m., and I will find that for the court.
Okay, well, we can find his testimony.
Okay.
Okay, let me see if there are any further questions. No, thank you.
Thank you.
We have your briefs. All right, let's see if I get this right now. Is it Attorney Bouillon?
Yes, Your Honor.
Thank you.
Good morning, members of the panel, and may it please the court. My name is Laura Bouillon on behalf of the oldest child. This case is precisely what Chapter 119, Section 26BB was designed for.
I want to ask, we heard the twins' counsel, I believe, say that the son is with the parents now and the case has been dismissed?
Understanding that that's, actually, that is in the record, Your Honor. I provided a supplemental record appendix, and that is true, Your Honor. My client is home with parents, and his care and protection case has been dismissed.
So what's left of your appeal? It's just the visitation order with the siblings?
Yes, Your Honor. My client and his siblings petitioned the court in November 2022 for sibling visitation. After trial, DCF cut their visitation in half, which led to the petition, and the court denied their petition on improper grounds. She failed to consider any of the statutory factors, that the visits were reasonable, practical, and in the children's best interest, and she should have ordered them.
When DCF reduced the visits, did they explain why they did that?
That is not in the record, Your Honor, so I don't know that if they did or not. The legislature understood the importance of protecting sibling relationships, particularly where children are separated by state intervention. Therefore, it requires that the court enter orders for sibling visitation if the requested visits are reasonable, practical, and in the children's best interest. Throughout the trial, the children had twice per month in-person visits and weekly FaceTime calls. After trial, DCF cut those visits in half to once per month. The children petitioned the court for twice per month visits and weekly FaceTime calls that they enjoyed prior to.
It seems to me that the court found that it was in the best interest of the children to have visitation, sibling visitation, right? I mean,
Correct.
I think we can all agree that that's the court's position. The issue was not ordering any and deferring it to whether it was the department or the adoptive parents. And it seems like there was some discussion about that and that she was fairly thoughtful when she said she heard from the adoptive parents and that they were committed to having visitation or allowing visitation for the children. So what was wrong about that thinking?
What was wrong about it, Your Honor, is that although the court considered the pre-adoptive parents' opinions, their opinions are irrelevant. These children have a right to visit with one another and have access to one another. It's a statutory right.
I don't know that it was their opinion, right? Because the parents, the pre-adoptive parents, supported sibling visitation. I didn't see anywhere in the record where they were suggesting that it should just be left to them.
The court made a finding that the pre-adoptive parents, by their testimony, would facilitate sibling visitation. However, the court then, when considering the petition for sibling visitation, fears that the adoption would fall through or questions whether the adoptive placement would be disrupted should she make the requested order for sibling visitation. That is not an applicable factor. The statute, the court shall enter the sibling visitation order if the request for visits is reasonable, practical, and in the children's best interest. Here it was, but during the petition hearing.
I think the judge could consider, as part of the assessment of whether it's in the children's best interest, that ordering visitation on a particular schedule might impede the adoption, and that that's not in the children's best interest. Do you think the judge could consider that in the rubric of children's best interest?
I think that the judge may. However, she found after trial that ongoing sibling contact would be in the children's best interest.
Sure, but we're not, I mean, it's an interesting situation here because the judge clearly found that sibling visitation was in the children's best interest, but then didn't order a schedule. And what I really understand your argument to be, the sibling visitation argument as presented by all the siblings, that they want an order, they want a schedule. They don't want just a finding that it's in their best interest, they want a schedule. Correct?
Yes, Your Honor. They want an order protecting their right to sibling visitation. The judge found that it's in the children's best interest, but failed to order anything. They were
All right, so is the
dissatisfied.
order you're looking for an order that says there shall be sibling visitation at the discretion of the adoptive parents or pre-adoptive parents or DCF? That's the order that should have been included in the judgment?
No, Your Honor. We would argue that the children's requested visits should be ordered. Therefore, we would ask this court to
You're looking
reverse.
for a schedule. That's what I'm trying to say. You're looking for a schedule, not just an order that reflects what the judge already found, which is that it's in the best interest.
Correct, Your Honor. We would like this court to reverse the trial court's decision denying the petition, therefore allowing the children's petition to have their twice per month visits that they requested.
Well, even if she were to order visitation, it doesn't necessarily have to be on the schedule that the siblings would like it to be. I mean, you agree with that, right?
Your Honor, if the children's request is reasonable, practical, and in their best interest, the court shall order it. In this case, she failed to consider any of those factors. She, instead of looking at whether these requested visits were reasonable, practical, and in their best interest, she instead focused solely on the adoptive parents' wishes and whether the adoptive...
I heard that. She said that she was very confident that the pre-adoptive parents would ensure that sibling visitation occurred. And
She
so
did make...
That's why she was not inclined to impose a schedule or to order it. Go ahead.
She did make that finding, Your Honor. However, at the hearing, she was very concerned about if she made any specific order that the placement would disrupt or the adoption would fail to go through. So there's two contradictory opinions by the judge going on here.
Let's say that she ordered visitation and it wasn't the schedule that the children advocated for. Would that be error?
If they are reasonable, practical, in the children's best interests, the court shall order them per the statute. So if
So is that
she
yes?
found, so we would argue that the requested visits were reasonable, practical, and in their best interest, but if the trial court found that it wasn't, but some other level of visitation was reasonable, practical, in their best interest, they shall order that schedule.
All right, so I take it that your argument is twofold. The first is that there just needed to be an order, a visitation order, and the second is that it needed to be on the schedule the children requested.
Yes, we would argue that the schedule that the children requested was reasonable, practical, in their best interest.
Okay.
And the judge failed to
And let me
consider-
see if there are any further questions. No. All right, thank you very much. All right, now Attorney Frizzoli.
Good morning, Your Honors. Carol Frizzoli on behalf of the Department of Children and Families.
Good morning. Can you pick up where the other side of the V kind of left off and tell us why the visitation schedule was reduced or adjusted?
Your Honor, there's no evidence on the record as to why it was reduced, but it was bi-monthly, so every 2 weeks, and then after the decree came out, it was monthly sibling visitation, but there still was the FaceTime, the virtual calls between the siblings.
And we have no idea why that happened.
There's no evidence on the record that as to why that was. And these motions...
Isn't that problematic, though?
Your Honor, again, because there's no evidence, we'd be speculating as to why they were reduced.
Is it a problem that DCF never explained to the parents or the children why the visitation had been reduced?
Again, so it's my understanding that this motion for visitation was issued after the findings came out. They filed a motion for a petition for sibling visitation. And there was a hearing at that time. It's part of the transcript of this case. And the judge...
There's nothing in the transcript, just to make sure, that where DCF says, here's why we reduced the visitation.
DCF's position was it should have been left because of the judge's order about having confidence in the on the pre-adoptive family. It was the department's position that the adoptive family, by reducing it to once a month, but keeping up the weekly, it was probably setting for. The inference could be that it was based on the adoptive family. Again, there's nothing in the record to say that, but
well, I'm even unclear about what there is in the record to demonstrate versus merely allege that visitation was reduced. But is there something that indicates that actual evidence rather than an assertion that it was reduced and that it was done at the instance of the pre-adoptive parents rather than DCF?
no, Your Honor, there is no evidence to that.
So we don't know why the visitation was reduced or at whose decision?
We do not.
So
based on
doesn't
this
that
record.
sort of highlight the problem that of the fact that the children were not protected by a visitation order? Because it seems to me there are two levels of this issue. The first is that there's no order at all, right? There's a finding but no order. Would you agree with me that the better practice would have been for there to have been an order where there was a finding made that visitation was in the children's best interest?
Your Honor.
Because there's nothing to enforce without an order.
Well, there is in the sense that the children have the right to petition the court.
Yeah, but it's a little bit different to petition the court with an order in hand than no order in hand.
And in this case, the trial judge heard testimony from the pre-adoptive family and felt confident. The pre-adoptive family testified that, or the mother testified that she wanted an open-ended relationship with this family. And so
that's not even reflected in the order, though. Then we don't even have an order that says there shall be sibling visitation, the timing of which shall be at the discretion of the pre-adoptive family. They don't even have that.
Your Honor, I would agree. There is no order.
Okay, so there's no order. So that's the first piece of it.
I would agree that the judge issued no order.
Right. And would you also agree that the judge should have issued an order given that there was a finding that sibling visitation was in the children's best interest?
Your Honor, I would not agree with that because of care and protection of Garrett, which allows the department concurrent jurisdiction for it to manage. And from the decision that the trial court gave post-trial,
Maybe I should phrase my question differently. What if DCF and the pre-adoptive family say, yeah, no visitation?
if they said that the children still have the opportunity to petition the court, and they were
But they don't have
represented
an
by counsel.
enforceable order in hand saying that any visitation. You see that there's a vacuum here, I think. There seems to me that there are two levels to it. The first is there's no order at all, and the second is, even if you had an order, is the question of whether it required a particular schedule to be set forth. But the first part is troublesome to me, that there's no order at all.
Your Honor, again, given what, after a hearing, the trial judge agreed that care and protection of Garrett, which was satisfied with the department at the time who was administrating the sibling visitation. They were ensuring that these siblings were seeing each other. So that's where I believe the judge, that's why the lack of order. Your Honor, I
Is
would...
the parent's decision, the pre-adoptive parent's decision, reviewable by the court for abuse of the discretion that the court previously left to them?
So essentially, there's a remedy.
Given that 26B
Yeah,
confers, and
the
Garrett
remedy would be for the children to be able, they would be able to petition the court for future visitation, as was done in the Jamison case, where the child came in and wanted visitation with his siblings.
Okay.
But didn't the...
Go ahead, I'm sorry.
Did the post-trial petition here effectively serve as just that? Saying, okay, you left it to the pre-adoptive parents, but we're not happy with the visitation they're actually providing. It was cut in half. And court, please do something about it. Judge, please do something about it.
Again, that was the motion that was filed. They wanted more visitation, sibling visitation with their siblings, which, again, but the remedy is always there for the children to petition the court.
Okay, so what's our standard of review of the judge's decision on that petition?
It would be abuse of discretion, Your Honor. So
So if there's nothing to indicate why it occurred, wouldn't that necessarily be an abuse of discretion? There was no evidence in the record to show why DCF reduced the amount of visitation. On what basis do you argue the judge could have decided that that was okay?
what the judge did do is, again, recognizing that sibling visitation is an important part of this case, after hearing the motion and having the evidence before her that the visits had been reduced, still didn't issue a visitation order. So again, was satisfied with the department's administration.
How can she be satisfied when there's no evidence as to the reason?
Again, there's nothing in the record which gives a specific reason, but she did hear testimony at that hearing, I believe it was an evidentiary hearing, or the affidavit of, and it believed that the once a month satisfied the sibling visitation. So it's the department's position that that is not an abuse of discretion because the department was still administrating these
So
visits.
we've now heard that the visits, in-person visits, have been reduced to every other month, so even half as frequent.
Your Honor, again, that's beyond the record, and I'm not aware of what these visits are currently.
Is that affidavit in the record? I do see a reference to it in the transcript that was submitted at the very end of the hearing. I think the judge actually said, well, you can dock it. I didn't consider it as part of my decision because I think this was a legal issue. That's at Record Appendix 9, page 480.
Again, I believe the judge thought it was a legal issue because, according to Care and Protection of Garrett, it gives the department concurrent jurisdiction to administer the
Right, but I think you're telling us that the department's decision is reviewable by the
Yes.
judge.
Yes,
Okay.
absolutely.
And there's an affidavit that is referred to. Number one, do we have it in the record anywhere? And
I believe it's the affidavit of, I think, the children put in the affidavit, I think of the bonding expert, Dr. Duran, is part of the record on the motion or the petition for sibling visitation.
But that it's not going to contain an explanation as to why DCF changed the schedule, correct?
Correct, Your Honor.
Well, isn't that important? I mean, the children are first of all, throughout trial, they had an opportunity to visit more frequently with each other and seemed okay with that. They advocated for more visitation time. They end up getting less visitation time, and nobody knows why. I mean, isn't that a problem? These are children with special needs who've been found to be in the best interest of the children to have sibling visitation. It's get cut in half, and nobody can explain to them or us why.
Your Honor, I would agree that the better course of action in this case would have been to have evidence of why it was reduced and to justify what the trial court did in this case, trial judge. But I believe the trial judge felt the confidence she heard firsthand the testimony of this foster mother. And I believe that her decision was based on that, on her even-handed credibility determination of this foster mother.
But that's not the question that was before the judge. The judge is, what was in the question was, what was in the best interest of the children with respect to sibling visitation, not whether you have confidence in the pre-adoptive mother.
I would agree that the sibling visitation is definitely determined what is in the best interest of the children. I'm just saying that was a factor
Sure.
in the judge's ultimate decision.
I don't want to, if there are no more questions, yeah.
Yeah, I do have a question. At the portion of the transcript I just referred to, which is the very end of the February 1st of 23 hearing, it's Mr. Bernard on behalf of DCF counsel, who says, my client did draft an affidavit. I didn't submit it when I submitted my opposition. Can I docket it? And the court says, okay. So presumably that has something to do with DCF's position about the current state and reason for sibling visitation. I don't see that in the record.
And Your Honor, there wasn't anything included in the record, so I assumed that the trial counsel never, followed up and submitted the affidavit. I would certainly welcome the opportunity to see if it ever was, and submit a 9C letter to the court if that affidavit was submitted. That attorney is no longer employed by the department, so I would just have to check the court record to make sure that was included. If it was filed, I do believe that would be reason, and it should have been in the original record. But again, I didn't catch that in the briefing, so, but I'd be happy to research that, and if it is, I would like to be able to supplement the appendix, if there is an actual affidavit that was before the judge.
Well, why don't you look into it and send us a letter
I will, certainly, Your Honor.
within a week, but we don't want to see things that weren't included in this
Absolutely,
record.
no, I would only submit it if it was part of the trial court record.
So moving away from visitation for a moment, can you address the staleness argument?
Certainly. So again, this is a family history of a 7-year history with the department. The trial court properly considered past evidence in the sense that in this case, the facts here are there was an original C&P with child 1 who was in the custody of the department, placed in a residential placement for 4 years, was placed back into the home in January of 2019. There was a 9-month period where these 3 children were living together with parents.
I'm sorry. At that time, were the parents still caring for, I'm going to say the grandparents?
No, Your Honor. I believe at that time they had left the grandparents' house. So it was the parents. This is the test. This is the family home. And in that 9-month period, there were 7 reports of abuse and neglect filed, involving physical abuse of child 1, involving medication unauthorized by by that mother and father. There was a lack of supervision. There was a child one who was seriously, had a broken arm, and for 5 days not attended medically. There was substance abuse issues. There was allegations, again, 7 reports of abuse and neglect during this 9-month period. That was very telling to this trial judge.
3 of those got screened out.
Correct, Your Honor. Again, but the investigation, when they went to remove the children, the house was in chaos. Their children were running up and down. So, as Your Honor, I think pointed out earlier, the lack of supervision was a very big issue here in that 9-month period. Now, at the time of trial, the trial court, again, parents should be commended. They did do, as they said, they did do the work. They did do their action plan. What the trial judge had in this, after 11 days of testimony, was evidence that although the parents did the tasks, they didn't, the lack of transparency with the department and with the court was indicative of what that past behavior was. So it wasn't that the judge relied on it, it was that it was prognostic to what was happening exactly at trial. For example, the father, there was domestic violence in the home before the children were removed. The child one talked about it with his therapist. There was findings on this about the domestic abuse. Again, parents never really acknowledged. They said it was just verbal disagreements. Never went forward and saw that their conduct impacted these children.
But DCF didn't make that part of an action plan for them, did they? Was domestic violence part of their tasks?
There was therapy and acknowledging the reasons for the removal of, why the children were in state care.
Domestic violence part of their tasks?
I believe in the action plan, there was no specific, it was such as substance abuse, domestic. It wasn't, they didn't, like, for example, the father wasn't required to take an intimate partner course because he had previously done one through, from my understanding, from a domestic violence incident with mother earlier in the case. So there was...
Where the judge found that the parents did the work, and everyone agrees that they did the work, it puzzles me, and frankly troubles me, that the judge did not make an explicit finding that despite those efforts, she remained convinced that they would be unable to parent all 3 children were they to be returned because of what happened in 2019, based on the pre-removal behavior. She doesn't make that finding. Did she? I didn't see it.
In her conclusions of law, she does talk about that culmination of factors. And what I think was telling to the judge was the lack of transparency with these parents. For example, no one is stating that mother had a substance abuse issue, but it was her lack of acknowledgement till day 3 of trial that she was an alcoholic. Again, it wasn't that she had to say it, it was that...
The judge never ties that to fitness or unfitness.
But what she does is that she found that that at the time of trial, 3 children, that parents were unfit for all 3. These are children of very high special needs. Again, at the time of trial, child 1 was in residential care, was still demonstrating, was not ready for a step down. His therapist testified he was still demonstrating sexualized behaviors, had to be in a single room, was not ready for discharge from this. And then you had twin 1 and twin 2, one of the twins who still had not had a dry night. I mean, so we had, and had very difficulty with transitions. The other twin, there was concern about her aggression towards her sister. Again, all of these, we have 3 kids of high special needs, and the parents were found unfit to be able to parent them. Now, with respect to the one child that where she didn't terminate the parental rights, it was because that child expressed that he did not want to be adopted. He said that to numerous people.
He's 12.
He's 12. And so he had that legal right to do that. And so the trial court wanted to give, Mother but again, at trial, Mother was found unfit with respect to him, but did not want to terminate her parental rights with the hope of the future, which is exactly what had happened, that they would be able to parent one child. The trial court made findings or in her conclusions, outside of a structured environment. The parents did have a lot of visitation in this case, and they did very well at visits, but in a structured, supervised environment. The family visits were at the...
We're going to have to leave it there because your time has expired, unless, let me see if there are further questions.
My only question would be, why not the same hope for the twins?
Your Honor, again, the parents were found unfit. These are 3 specialized kids who have really high special needs. The trial judge, after 11 days of testimony and hearing from all sides, determined that these parents, with respect to the twins, it was in the twins' best interest to be adopted. And the only...
I'm going to see if there are any further questions.
I do have one further question. During Father's counsel's argument, she said that DCF had taken the position during the trial that the visitation schedule could not be modified. Is that in the record, and was that DCF's policy, and is it a policy that goes beyond this case, or was it a specific position in this case?
Your Honor, I'm not aware that it's part of this record. It certainly could be in a court report that is in the record, that the parents did move for additional visitation. But again, in this case, the parents were given very frequent visitation, and...
I just want to, so we can pour through the record and see if there is anything. Is there a policy of DCF or a general practice that visitation will not be modified while a trial is underway?
No, Your Honor, there is no such policy. Again, if the goal was to transition these children back to the home, then, in fact, visitation would be increased. Visitation would be reduced to unsupervised if that was the goal of this case, but it clearly was not.
Okay, thank you.
All right, thank you. We're going to have to leave it there. Thank you all for your able argument and your very helpful briefs, and the case is submitted.
Thank you.
All right, you don't need to wait for me to call the case for it to come up to approach, but the next case is 2022P1010, James Lyons versus William Johnson. Is it Attorney Tauchis?
Couches, yes, Your Honor.
Tauchis? We are ready whenever you are.
Sure. Good morning, Your Honor. I'm Jason Tauchis, and I represent William and Gail Johnson in this appeal. All right, in Squeary versus McCarrick, this court...
You may want to adjust the microphone and just speak up a little bit. There's no substitute for projection.
Yes, Your Honor. In Squeary versus McCarrick, this court found that there are trials which are so laden with error that it's incumbent upon this court to look at both those preserved errors and non-preserved errors in order to ensure that substantial justice occurs and to prevent injustice from occurring. This case is one of those cases, Your Honor.
Can we talk about your first argument? It's unusual to see an appellant argue that their own appeal is premature, which is essentially what I understand your first argument to be. So why didn't you just dismiss your appeal?
Your Honor, because we're saying that the appeal is premature because if we dismiss the appeal, then there's no other avenue for a new trial. Whereas if there's...
Well, you can seek a 54B certification from the judge and come back here in the existing state of affairs, or conceivably the fraudulent transfer claims could be tried so that every claim is addressed, and then you could come up on a final judgment.
Yes, Your Honor, that is a possibility, but we'd rather, instead of the fraudulent transfer claims being adjudicated, if this court agrees that the case is still live and there is no final judgment in this case.
We're not going to have a lot of choices here. This is not discretionary. If there's no final judgment and there's been no 54B certification, I think we have to dismiss it. Normally, we would have seen a motion to dismiss it on that basis. I understand your first argument to be a motion to dismiss. What else could it be?
Well, Your Honor, it's a ruling by this court saying that there is no final judgment in this case. That is what I'm looking for with that 54B. Not that this appeal
But you
should
didn't
be...
seek a 54B, did you?
I did not, Your Honor, because I believe that it was not that there is no final judgment in this case. I sought a new trial in the trial court, which was denied because they stated that this was a final judgment. And so, I believe that there is no final judgment in this case, but in terms of the trial court stating that there is a final judgment in this case, which I believe there's not, in order to be able to have a new trial or a motion for a new trial, then this court must find that there is no final judgment in this case.
Let me maybe put this another way. If we agree with your first argument, what is the relief here?
The relief is that this court would find that there is
We make no findings in this court.
Yes, Your Honor, that this court dismisses the case because there is no final judgment.
Okay, and so then what?
And then
So we dismiss this appeal, and then there was a subsequent amended judgment from which you did not file a notice of appeal. Do you see the problem?
Yes, Your Honor. But at the same time, there's a substitute amended judgment, which we would then also state there is no basis for, that it's not a final judgment, and we'd file a motion for a new trial on that case, on this trial, that there should be a new trial in this case, in the trial court.
May I ask, if we agree that there's no final judgment, could we stay appellate proceedings and give the trial court leave to consider a motion under Rule 54B? And if we could do that, would your client make such a motion, agree to it, oppose it? What would the position be? So that at least if that happened, we could then adjudicate at least what the claims and arguments that are before us, even if we don't get to the fraudulent conveyance issues, and even if there's no appeal from the amended judgment, which I gather added Gail Johnson as a defendant?
Your Honor, it added Gail Johnson as a defendant for one.
Yeah, okay.
For one-
So, all right.
Your Honor. So we would, if there was a 54B motion, we would oppose that motion. We believe that.
Why?
Because we believe that this is still an ongoing case that is not ripe for appeal. There's still 14 fraudulent conveyance claims out there, and it would allow us to file a new trial motion.
Why would it allow you to file a new trial motion?
Because a trial court is allowed to reconsider any judgments that it made, including a judgment made on a jury verdict, until a final judgment. And
We could retain jurisdiction, simply stay the case, let you to decide whether to file a Rule 54B motion, and for perhaps the plaintiffs to decide whether they're going to dismiss down below the fraudulent conveyance claim. And if that happened, then there'd be a final judgment entered, and the case would still be here, and we would then reach the arguments that have been presented.
Yes,
Isn't
Your
that,
Honor.
doesn't that seem like a way to, if you want us to reach the arguments that you've presented, that seems to me like a pragmatic way of trying to get this appeal on track.
Your Honor, what would be most favorable for the appellants, for the defendants in this case, is that the court dismiss the case because there is no final adjudication, and we're allowed to submit.
You don't need us. Why don't, you could just file a motion. Why can't you just file your own dismissal of this appeal?
And have the court dismiss the appeal. If that would state that the appeal, that the case still has no final adjudication. The issue that I have in this case, Your Honor, is that the lack of objections from the trial attorney, especially with the egregious improper closing argument in this case. And in terms of the review by the court, by the trial court, we would have an ability to review that in the trial court through a new trial motion. And that is...
No, there were no objections. It seems to me that if you have a claim, you might have a separate action for legal malpractice based on that, but this is not a criminal case. I think waiver still applies in civil cases, and there were no objections to the closing. So in this, what you're bringing as a direct appeal from the judgment, I don't see how you get review of those. If you want some kind of collateral review of them, it seems to me you might have a different type of action that you need to bring.
Your Honor, if there was no final adjudication, I could bring a new trial motion where the improper closing arguments would be able to be reviewed by the trial court, and then that would be able to be reviewed. Any denial of that would be able to be reviewed by this court.
I don't know if the trial judge can do that where we have jurisdiction of the case right now. Do you have a case that says they can give you a new trial while you've brought an appeal here in the appeals court?
No, Your Honor, but if this court,
Right.
if this court says that this case is not ripe for appeal and dismisses it based on a lack of 54B determination, then I can bring that new trial motion.
All right, well, I think unless there are further questions on that, you may want to.
Yeah, I have a question that sort of goes to the merits. Why don't we have the transcript of the end of all the evidence on April 21st, at which the plaintiffs moved for directed verdict, and according to the docket entry made by the judge, or ordered by the judge, the defendants acknowledged that the evidence was sufficient on liability, and they only wanted to go forward on damages. We have a partial transcript, or a number of partial transcripts for that day, not a whole one.
Yes, Your Honor, it was my understanding that that transcript was created and given to the trial court, but I can ask that the transcript be created, or if it was an oversight, Your Honor.
Well, isn't that pretty important to your arguments?
It's important to one argument on the directed verdict for an IED claim. That was after that was in that transcript, Your Honor. It was just based on that one argument based on the IED claim.
Well, it seems to me it goes to more than one argument, because from the portions of the transcript that are here, it appears that everyone in that courtroom was operating on the understanding by the time of the closing arguments that the only issue to be tried was damages. And consistent with that was how everyone structured their closing arguments, and how the judge instructed the jury, and how the verdict slip was phrased and set up. And none of those were objected to. So unless, I don't know what we can do in the absence of those transcript portions to find anything other, or to conclude anything other than that was agreed to by defense counsel down below.
Yes, Your Honor. I agree with that.
Okay, so then if that's true, then what's left of your arguments?
Well, Your Honor, that there was, as I stated in Squirry versus McCarrick, that there are cases where there is so much injustice, that there's so much error, that in the aggregate, that the court must look at both preserved and unpreserved errors in order to ensure that substantial justice occurs. And in this case, there's both preserved errors and unpreserved errors that...
You say that, but isn't that difficult for us to do without the adequate transcripts?
Your Honor, the lack of the transcript is possibly 20 minutes of a 4-day case, and deals primarily with with one motion for a directed verdict.
What argument that you're raising here on appeal was preserved down below?
Your Honor, that the partial or summary judgment motion was granted without sufficient factual basis, that that an unpleaded, unnoticed claim of assault from 2010 that was raised during trial 2 years after the statute of limitations had expired was allowed to proceed on liability without counsel for the defendant knowing that the evidence that went towards that claim for assault was for a claim for assault. He thought it was for a claim of harassment. That's one of them.
How was that preserved?
I
didn't see any objection at the argument on the defense motion for directed verdict when plaintiff's counsel says, well, there was the incident with the fingers put to the head like a gun that supports, that is evidence of assault. I didn't see any objection, like in so many other instances in this case, from defense counsel saying, no, I thought that was only related to the harassment issues.
Your Honor, he stated that when the case first started, when he was talking, after the initial opening arguments, where that was mentioned, the counsel for the defendant stated that he saw several claims or unnoticed claims of harassment. He was under the impression that it was unnoticed claims for harassment, and then when he made his directed verdict, he said he saw that there was no evidence of a claim for assault, especially since the claim for assault that was in the amended complaint was from 2008 and was...
So tell me this, how did it make a difference whether defense counsel understood that the evidence of the finger gesture had come in as evidence of harassment, whereas the plaintiffs argued that it could be considered for evidence of assault. Neither of those statements ever made its way to the jury, and the jury was not asked to break out its damages awards based on, what's for intentional infliction and what's for assault. So how does it make any difference what counsel understood that argument to relate, or that evidence to relate to?
Yes, sir, because an unpleaded, unnoticed claim can only be litigated under Wolf versus Ford Motor Company and Harrington McGill versus Old Mother Hubbard Dog Food if the defendants were given proper notice of it and knew what claim that evidence was going towards. And since the defendant thought that the claim was going towards a harassment claim, and then it was brought towards an assault claim, then it was not given proper notice. The evidence was prejudicial and unfairly prejudiced my clients.
Is there a reason that you elected not to engage in any discovery?
Excuse me, Your Honor, sorry?
Is there a reason that you elected not to engage in any discovery in this case?
Your Honor, the reason at the time, I believe it was because the defendants were dealing with a criminal case that they were then litigating. I don't know why there was no reason for discovery in this case, but at the same time, any discovery in this case would not reach the 2010 claim, since it was not in any of the pleadings, not even in the pretrial brief.
I don't understand this argument, but we're probably going to need to leave it there. But normally, the pleadings conform to the evidence. So let me see if there are any further questions. All right, we'll have to leave it there. You're out of time. We've got your brief. Thank you very much. Is it Attorney Gillis?
Yes, Your Honor. Michael Gillis for the appellees. I'm not sure what to argue because I believe that I agree with most of what you've said.
I would ask you to start with the first procedural issue. If we were to stay, it seems to me there are two things. Either the appeal needs to be dismissed because it's premature, there's no final judgment, or we could stay the appeal to see if the state of affairs down below can be somehow brought into the required state for us to act on this appeal. And the two options there would either be to get a Rule 54B certification, or perhaps that you could dismiss the fraudulent conveyance claim, and then a final judgment could enter, and then the case could arguably be here properly. What would happen were we to stay this by your clients? What would your clients do?
I would think they'd do one or the other. They'd either dismiss it outright or they'd ask the court to go forward with the second action, so there would be no question that there's a final judgment. I think clearly the defendant here thought there was a final judgment. We did too, because they filed their appeal 6 days later. Then the amended judgment was entered. There was a judge specifically put in there that the 106 claim was stayed. He dismissed those actions that weren't argued at trial, and then he ordered that a judgment enter on this case. And that, as you correctly stated earlier, was not appealed. So I don't think they have any right to appeal.
Right, but then there was subsequent litigation concerning the fraudulent conveyance claim, including, if I read the docket properly, submission of additional briefing. It looked like the parties were called in for a pretrial, and then it seems to have just sort of died on the vine.
Yes, Your Honor. The defendant was in bankruptcy and was a stay at that time, so we couldn't go forward with it.
Okay, so, I mean, the fact of the matter is that there is no final judgment, because those claims survived the judgment that was entered after the trial, and there doesn't appear to have been a judgment entered at any point afterwards on the fraudulent conveyance claim. So what should we do in your perspective?
I think where the matter's already been briefed and we're here before the court, it would be better to stay it as opposed to dismiss it, because then it just starts the whole procedure. But
And then what will your clients do?
either dismiss the Fraudulent Conveyance Act or move that it be heard by the court so that we have a final judgment.
What about a third option, which would be to seek a 54B certification so that the issues that are up here could be adjudicated?
That would be fine. I could do that as well, Your Honor.
All right, well, we would not stay for you to try your fraudulent conveyance claim.
Then I would ask that the appeal be dismissed, or that we have the option to go back and get a 54A certification from the court.
All right, I guess we'll leave it there on that argument. You know, we can't order you we can't order you to file a motion down below, I don't think, but maybe we can. And we
Right.
certainly, you know, but, and we can't hold on to the appeals forever.
Sure.
So, well, we'll give that some thought.
Thank you.
All
Would
right.
you like me to address any of the other issues, or
I don't know, you know, we have your
we
brief.
have to?
You're, of course, free to argue whatever you'd like to argue in your time. I can see if there are any questions for you.
Spent a lot of time on it, but if there's no questions, I think we're already behind in
Do you
time
want
for
to
the
rest
day,
on,
and I'll let you
can
guys
rest on
decide
your
from there.
brief? Yeah, we have your arguments, so.
Thank you very much, Your Honor.
No problem. All right, thank you both. All right, and the case is submitted. The next case is 2023P 0078, Heather Hill Investments versus Long Built Homes. And for those of you who are waiting for the remainder of the cases, we're going to take our morning recess after this case, and it'll be like 10 or 15 minutes.
Good morning, members of the panel. May it please the court, my name is Pavel Bespalko. I represent Long Built Homes, Inc., which is the appellant in this matter. The appeal concerns the entry of a partial summary judgment by the Superior Court declaring that the operating contract expired, but also ordering a turnover remedy, which was only applicable on default, which was never found and never existed. Long Built submits here that it was denied the opportunity to present this case at trial, and it was denied this opportunity improperly because the court committed a number of errors of law and of fact. In addition to that, the remedy that was ordered, namely the turnover of Long Built's permits and engineering collateral to Heather Hill Investments, the plaintiff in the original case and the appellee here, was entirely improper.
Would that have been proper had there been a default?
Yes, had there been a default, it would have been proper and in accordance with the contract. However, no default was found and no default existed in the circumstances of this
Can we look at the
case.
language of the contract?
Yes, we can look at the language of the contract,
I'm
Your Honor.
looking at specifically paragraph 18.
So this would be, yes, paragraph 18, Your Honor.
And I think what we're talking about here is the second paragraph of paragraph 18.
Yes, and I would submit, so
And
we will
I-
discuss it.
I have a question.
Oh, yes, I'm sorry.
That's okay. So, so the first sentence here says, notwithstanding the foregoing, which I I interpret to mean by foregoing the previous paragraph within that section. In the event that the buyer defaults, and it used the word defaults there, under this agreement, by failing to close on a timely basis on the purchase of the Phase 1 property. Now, it seems to me that on this summary judgment record, it was undisputed that there was no closing on the date. So why is it that just by reading this language, that the failure to close the Phase 1 on time, it's not a default? It uses the word default there.
Yes, so I would like to answer that question holistically because there are a number of reasons. First, we find the reasons in the contract. Now, my client only had to purchase this property in a certain set of circumstances. That is, if certain conditions were met. If the conditions were not met, it had no obligation to buy this property timely, untimely, or ever. As you have seen from the record, this was intended as a purchase of a 200-acre golf club to develop into a senior housing
is there a
development.
specific provision that
Yes, sir.
says we don't need to buy the property
Yes.
if you don't, okay?
Yes, there are a number of provisions
I'm looking for
actually
one.
that talk about, well, okay, let us
And,
start
and,
with
and there's
section.
one that says we don't need to perform if you don't perform
So
first.
let us look first at section 24 of the contract, which says that it's a condition to buyer's obligations, right? The buyer's obligation to consummate each of the conveyances contemplated hereunder is expressly subject to the satisfactory fulfillment of the following conditions, hereby referred to as buyer's closing conditions. I will refer you to section C, the issuance and continued validity of a number of permits that are sufficient to build a certain number of units at the property, and the validity of all of those permits and other matters has to be as of the closing dates, and it has to permit my client to build a certain number of units. I will also refer you to
Right,
section 6.
but that's not an obligation.
This is the obligation to consummate each of the conveyances contemplated. Sorry.
That's not a condition on the seller, right? That's a condition that you're making conditional your obligation to purchase on receiving the permits that you were in the process of trying to do.
Yes.
Okay. So, but how does that help you here?
So if the permits are not issued by
Right.
the town of Plainville
Yeah.
in time for the closing, my client has no obligation to purchase this property. And this ties into a number of other
So
provisions.
how do you reconcile that language with the language in 18 that says it's a default if you don't close by the date?
So what is contemplated, again, there are a number of other provisions that contain similar conditions, right? There have to be permits in place, otherwise my client doesn't have to pay the money. Otherwise, it doesn't have to consummate the closing. So to tie it into the provisions of Section 18, if the permits are issued and existing, and my client fails to purchase this property by a certain date, then it would be in default of its obligations because the conditions have been met. This has never happened in this case. It's undisputed. Now,
I want to understand how 28 interacts with paragraph 7, the time for performance, which says the Phase 1 closing shall take place 30 days after terms and conditions of this agreement have been fulfilled, including but not limited to the buyer obtaining all permits, approvals, et cetera. But in no event later than December 31st, 2020, or if there's been reasonable diligence, then in no event later than March 31st, 2021. So that seems to say the time to close is within 30 days after all permits, but in no event, that would seem to mean regardless of whether the permits are in place, in no event later than March 31st, 2021. So a closing after March 31st, 2021 would be untimely.
well,
And therefore, why wasn't there failure to timely close under paragraph 2 of paragraph 18?
so the answer to that is, if we look at all of the provisions of the contract and interpret them harmoniously, as we should under the the prevailing rule, then it's quite clear that my client did not have to purchase this property unless the permits were in place. We have Section 24, which says so expressly. Section 7 provides an outside date, and that date is there so that the seller does not have to wait indefinitely. If that date passes and the permits are not obtained, my client does not have to buy the property.
Sure, but
the
nobody,
seller
that's not
can-
the relief they're seeking here, right? They didn't seek to compel you to purchase the property.
Well,
They only are seeking the relief under 18, paragraph 2.
they did not seek relief under 18 paragraph 2 because they did not assert default in the original complaint. There is no count for breach of contract, and default obviously contemplates that the contract is
They're
breached.
seeking a declaration.
Yes, but they did not assert that the contract was breached. There was never any notice of breach. There was never any suggestion that Long-Built had
But
defaulted
right, but
under its
that's okay,
obligations.
right? Because no finding of breach is required in order to obtain a declaration as to whether or not they're entitled to the return of the plans.
Well, I don't think that that follows because the provision is quite clear. It says if my client defaults by not purchasing this property timely. However, it had no obligation to buy this property ever unless the permits were in place. This is supported by other provisions of this agreement, including Section 6, for instance, of the agreement that talks about the purchase price and the delivery of the purchase price. Again, the client did not have to tender under subsection D the first $8 million because it was to be paid at the time of the closing, assuming that all of the required permits and approvals have been obtained for the development of a certain number of units, which nobody disputes that this has never happened during the history of this case. Under subsection 16, if you look at my client's obligations, there was no guarantee that the permits would ever be obtained. In fact, what my client had to do is to ask for them and to prosecute it diligently, aggressively,
Sure,
and so
but
on.
I have a hard time understanding why you couldn't have an agreement that says, you don't have to buy this property, you buyer, if you don't get the permits by such and such a date. But if you don't close by such and such a date, then you need to turn over the permits and the paperwork to us as a form of damages, which is what it appears paragraph 18 is talking about. Why is that not a reasonable construction? It says, that's right, you don't have to buy it if you don't get the permits, but if you don't get the permits by such and such a date, then we get as damages the paperwork and the permits that you have obtained.
Well, it would have been possible to draft that kind of a contract. However, this contract is not so drafted if we interpret all of the provisions together. In fact, no party ever interpreted this contract in this particular manner. The paragraph 18 talks about buyer's default. Default implies that there is a breach of an obligation under the agreement. It says if the buyer defaults under the provisions of this agreement, not simply if the buyer fails to purchase. If they wanted to say that, they had ample opportunity to do so, as this agreement and the previous agreement was negotiated by the parties over the course of many months.
Well,
In fact,
18 does say defaults by failing to close on a timely basis. So we need to decide whether there was a failure to close on a timely basis, which seems to me to involve reading paragraph 7 about time and paragraph 24 somehow together. So what's your reading that harmonizes those two paragraphs?
And I think we also need to look at paragraph 6, which talks about the delivery of the purchase price, and at paragraph 16, which imposes on my client the obligation to prosecute the permitting. So in this particular case, the failure to consummate the transaction timely means once all of the conditions have been met. Under the law, which the lower court did not acknowledge, cite, or in fact discuss at any great length, failure of a condition means that the obligation under the contract does not arise. That is what we have in a number of paragraphs here.
Which paragraphs of paragraph 6 did you say were relevant?
So in number 6, we talk about the purchase price. So the purchase price is listed, this is the restated agreement, but it's identical with the original agreement. So I'm talking about paragraph D, for example, right? And D says that $8 million is to be paid at the time of the closing on the Phase 1 property by certain funds, assuming all the required permits and approvals have been obtained for the development of the Phase 1 property and a certain number of units. So again, the price is only to be paid,
I know, but
assuming
why
a
does that
certain-
matter here? No one's seeking to get $8 million from your client.
Well, again, I think the operative word here is default. Was my client in default by failing to purchase something they did not have to buy? The answer to that, from our standpoint, is obviously no.
Right, but it could be depending on the relief that's sought, right? So it looks to me as though the parties agreed that if a certain type of event didn't occur, which is a closing by a particular date, the remedy would be to turn over these documents.
That is not what the agreement provides. The
all
agreement
right,
says
I'm-
if the buyer defaults, that is breaches this agreement
Well,
by doing
you can't
something.
ignore the word "by." It doesn't help you. We're going to look at this document and take the language that's there, right? So it doesn't help to ignore what's actually there. It seems to, in paragraph 18, it doesn't seem to, it does say defaults by failing to close. So there's a particular type of default in paragraph 18, which is the failure to close by a particular date,
Well, but again, what
and
is
provides a specific remedy, a specific remedy.
Yes.
All right. It doesn't reference any other paragraphs in the document.
But it also does not define any of the terms that are employed here. So if we look at the term default in its regular meaning, it would mean a violation or breach of some of the buyer's obligations. If the buyer had no obligation to buy this property, which never arose because the conditions were not met, then obviously the buyer could not have defaulted on a timely basis or any other basis by failing to purchase this property. That is our position, and I think it's entirely consistent with the agreement, with the parties' conduct over the course of the years, because obviously there were closing dates that came and went, and nobody ever required my client to conduct a closing on any of those dates. If Heather Hill had a right to force my client to buy this property, permits or no permits, then obviously why didn't it do so over the course of 5 years?
Let me see if there are any questions. What, in your view, would be the legal consequence if neither, under the contract, under the terms of the contract, if neither side were prepared to close by the closing date?
So under the contract, there are two consequences, right? Under the contract, the first one, both parties had an opportunity to give a 10-day notice in terms of, and terminate the agreement. If neither party were prepared for the closing, which seems to be the case here, then I assume that it would depend on whether or not the conditions were met and whether or not there was a breach by one of the sides.
Okay. Thank you. I think we're going to have to leave it there because your time is up.
Good morning. My name is David Rich, and I represent the appellee, Heather Hill. I think to focus on the question that the panel spent the most amount of time on, I think we all agree all these provisions must be read harmoniously. And the only way to read all the provisions my brother cited to, along with paragraph 7, even if those are conditions to closing, is they are all modified by the requirement that the closing occur in no event later than March 31st. So if that is the date by which all of these things must happen, and in the event they don't, that is a default which triggers Section 18, the second paragraph, notwithstanding, as Your Honor pointed out. Otherwise, to read the contract in any other way effectively reads out paragraph 7's language, but in no event later than. It effectively
What
means...
happens if, in your view, if neither side is prepared to close by either of the dates in paragraph 7? What's the remedy then?
Well, it's an interesting question. I think, so you're saying both sides, well, I think your question presumes that both sides were able to close or willing to close on the date, and if neither side wanted to close, I would imagine the contract goes away.
It doesn't look to me, I mean, I think we have a lot of contract cases on the list today, so I may be getting them confused. But I believe there was it was not in the statement of undisputed facts. It was disputed. But in your brief, you nonetheless contended that your client was ready, willing, and able to close based on an affidavit, which was disputed. And it doesn't look like you showed up at a closing with all your ducks in the row and an $8 million check.
Well, my client wouldn't come with anything. My client would come with a deed because they're the seller.
Sure,
Right.
sorry.
Right, no problem.
So, but it doesn't look like you were sitting there ready to go.
Yeah.
Right? So if neither side is prepared under this agreement, it's hard for me to figure out who's supposed to be doing what.
Well, let me answer that in two ways. The first way is I fundamentally disagree that there's a dispute in the record about my client's ability and willingness to close on March 31st. There is some reference in the papers about that there were title issues, and I can cite you.
I saw the emails indicating that those had been resolved.
That those had been resolved. And so the only issue was, and if you take a look at my client, at some of those emails, my client's lawyer, Mr. Murphy, is saying, tell me in whose name you want the title. There was no response. My client writes, says, tell me, I'm doing work, I'm trying to get ready for the closing, and then there is no response.
And then he also says, tell me, I'm just going to stop working on the closing.
Right, because on March 16th, Mr. Castanetti told my client and then confirmed it in writing on, I believe it was shortly thereafter, we aren't able to close, which I think then you sort of take a step back, and this wasn't your question, but I think it's an important point, is when a material breach by one party relieves the other party of its obligation to perform. The other issue, and this is something that the trial court focused on.
There was no contemporaneous statement to the other side saying, we are ready, willing, and able to close on the date.
And I don't think that would be required.
I'm not saying it's required. I'm just asking for your confirmation that there wasn't anything contemporaneous to that effect.
No, I think as a practical matter, when Mr. Castanetti said we are unable to close on March 31st, my client took that to mean they were unable to close and there wasn't going to be a closing.
Okay, so now let's just go back to my question then. Assume that neither side is prepared to close by this closing date. What's the relief under the contract, or what are the remedies under the contract? And I'm not talking about it's anyone's fault. I'm saying it could be for anything. People are blameless. Both sides, neither side is ready to go.
Well, I think in the absence of a writing, which modifies the terms of the contract has expired by its terms. So at a minimum, they don't get to buy the property.
Exactly, fair enough. But do you think, so what would make us think that paragraph 18 gets triggered in that scenario?
Well, I would tend to agree with Your Honor if the buyer hasn't defaulted by failing to close on a timely basis on the purchase of Phase 1, then that provision, the damages, as you've referred to them, might be in question.
So here, what is it that So I'm struggling with why it is that it's not a question of fact as to whether both your client actually did not step away from the deal before the closing date too.
Because paragraph 18 says, in the event the buyer defaults by failing to close on a timely basis, and they announced 15 days before the closing they weren't going to be able to close, and then confirmed that fact in writing to my client on March 23rd. Castanetti writes, I indicated to you on March 16th that all the required permits have not been issued, and accordingly, we will not be able to close on that date. That's Record Appendix 3, page 49. So I don't think you can read that affirmative statement as somehow and then say, but we then didn't go and show up at this pretend closing prepared to close to be able to make a legal argument in court. I would argue that that conduct, as confirmed in writing by the buyer on March 23rd, which dates back to March 16th, from that moment forward, relieved my client of the obligation to go through these pretend activities to somehow be able to create some argument that we were ready, willing, and able to close.
May I ask about the use of the word default in the second part of paragraph 18?
Of course.
Default in its ordinary sense suggests a failure to fulfill some obligation. Now here, there's an argument that the paragraph 2 here defines what a default is, failure to close on a timely basis. But if the mere failure to close on a timely basis was supposed to trigger this, the remedies listed in paragraph 2, why wouldn't it have said, in the event the buyer is unable to close on a timely basis, rather than in the event that the buyer defaults by failing to close? Doesn't the use of the word default suggest that the failure to close on a timely basis must result from the buyer's breach of some other part of the agreement?
Well, I would argue that it is a breach of the agreement under paragraph 7 to not close at the latest by March 31st, and I think that's what this is saying. But further, I would say that the word default, I think you pointed this out in questioning before, the word default is modified by what follows, by failing to close on a timely basis. And if you take...
but it's still the use of the term default still has to be given some effect. It's a word that implies fault.
Well, but to me, it implies the failure to perform in a way contemplated by the agreement. And here, there's no doubt that what that is intended to refer to is paragraph 3, but no later, paragraph 7, I'm sorry, but no later than. And I think that's best evidenced by this paragraph which precedes it, which is a much more broadly speaking, if the buyer fails to fulfill or perform any of their obligations hereunder. So you're going from the very broad, and then I think the people who negotiated this agreement wanted to be very precise, that we're not just talking about any old thing, this too will qualify. And if you look, the remedies that are provided in that first paragraph and the second paragraph, they're not all that different. So I think it's an intention to make crystal clear, March 31st is D-Day, and if you don't show up ready to go, here's the consequence that you will suffer by failing to do that, in addition to losing your right to proceed with the transaction generally.
I want to make sure that we're not dealing here with something that's become moot. Has what, I'm trying to figure out from the dates when things were going to survive till, whether we're past the date where any of this matters. Can you talk to me a little bit about that?
Yes.
Because this is only the declaratory judgment act count, and I don't want us to get involved in something that, well, and nor are we supposed to get involved in moot questions.
Yeah, and from the state of the briefing and the state of the record, it's hard to tell
Yeah,
because
it
sort of
looks
what
like
happened next. The
June
permits were to
2023.
the permits were to, and this is outside the scope of the record, but I think that there is no dispute, and to the extent I think it's helpful in answering your question. The permits were to expire by their own terms at the end of July of this past year. In the beginning of July, my clients went to the planning board in the town of Plainville and made a motion that in light of this litigation, the board moved the deadline out. And they took a vote in July and they approved the motion. So they have extended the date, the expiration date on the permits until July of 2025. So in 2 years.
So in other words, things are still live.
Things are
It's not
still live,
moved.
yes.
Okay.
And to the extent the court needed some kind of affirmation of that, I could certainly file it, but I'm not
No,
sure
it's
that there
okay.
is. So unless there are additional questions, just the two last things I wanted to add, and they are referenced in the brief but didn't come up today. I think that the SJC's decision, quite a bit on impossibility of performance. The SJC earlier this year in the Lafort Enterprises case, 491 Mass 144, it's a 2023 case. I think that largely answers the questions, respectfully in our favor, but that wasn't in our brief. I think the decision came out just as we were briefing or just before.
I think we're all familiar with that case.
I think, so my fault for not finding it on Westlaw, but I just wanted to draw it to your attention. And lastly, there is some reference in the reply brief about that make certain accusations against me. And those didn't come up today, and I can answer any questions that the court has, but one of the things that was referenced is that I never denied making some misrepresentation to the court. And I would simply refer the court to Record Appendix 1, page 274, where I opposed the motion. It was actually a motion for reconsideration where I said, Long-Built and its counsel's accusations launched against plaintiff counsel are serious and sobering. Then I go on and said, the reason Long-Built has failed to provide evidence is because none exist. The claim is baseless, outrageous, and false. So I just wanted, to the extent the court has any, my absence of stomping my feet and yelling that I didn't perpetrate a fraud on the court, it is in the record. And of course, that's not why I believe the court denied the motion for additional time. And I tried to focus my comments on the standard, the abuse of discretion standard, and the history and what evidence they presented to the court in support of that request or absence of evidence. And plainly, from our position, there wasn't. But I did want to draw the court's attention to that denial, so at least the court has it.
One more question. That's what lawyers always say. Is there a claim anywhere in the case that that Long-Built defaulted by not using reasonable diligence to obtain the permits?
No.
No? Okay.
No, and
there's no such claim in the complaint?
There's no such claim in the complaint, and to sort of provide a little more, where
I think that's
okay.
Well, you still have your time, so go ahead.
Well, I was just going to say where I viewed that to be a material claim, but we intentionally chose not to go there because it was so fact-intensive, was this right to automatically extend from December 31st, 2020 to March 31st, 23. There was evidence in the record that they didn't even submit their applications until late January, but I felt strategically in terms of trying to get this case resolved as quickly as possible, and that was ultimately my client's goal, was to try and keep it to the language and getting into good faith and diligence. It's awful hard to argue that those aren't fact-based questions, so we sort of kept that, we kept away from making that argument.
So it's not merely not in the summary judgment motion, it's not in the complaint even?
Correct.
Okay.
Correct.
Thank you.
Thank you, Your Honor.
Do you have anything for it? All right, that's okay. I usually like to check for questions, but that's quite all right. With that, the case is submitted. Thank you both for your arguments. Thank you both for your briefing. And we're going to take the morning recess now. We will return in 15 minutes, so like 11:40 or so, assuming that.
All rise, please. Court is now in recess. Middleton versus City of Brockton. Have a good one.
apologize for keeping everybody waiting.
Court is at session. Please be seated.
All right, our next case is 2022P1190, Meadowwood LLC versus Brockton. So in this case, only one side filed a brief, so only one side is entitled to argument, but we understand that the plaintiff is nonetheless here represented in case we have questions that we want to ask of you. All right, so Attorney Galvin, is it?
Good morning, Your Honors. My name is Attorney Lauren Galvin, and I represent the City of Brockton in this matter, the appellant. The Brockton Planning Board properly denied the A&R endorsement of a plan submitted by Meadowbrook. The plan has been submitted to the court as the last page of the addendum, page 55, and that is really the only thing you need to look at in this case. It's also in the appendix in a few places, but I think the easiest place to look at it is in the addendum, the very last page. As a threshold matter, for a plan to be granted A&R status, which means approval not required under the subdivision control law, the plan must show all lots, every lot or lots have adequate lot area under the zoning bylaw, and that they have frontage on one of three types of ways.
So if the other side of this, hard to say because they do say lots and then they say one lot.
Yes.
But there's an area where it's supposed to be non-buildable, but it doesn't say non-buildable.
Correct.
If they would have just put in non-buildable there, would you say that this would satisfy?
No, I would not, because I think then you would have basically no lots. And there's no such thing as a no lot exception. There is the one lot exception, but there is not a no lot exception. And
Well, how is it a subdivision if there are no lots?
so the point of an A&R endorsement is that the plan does not need to go through the subdivision control law. The subdivision control law, chapter 41, sections 81K through 81GG, is meant to ensure that all lots that are being developed have adequate access on a way for public safety purposes. That's what the whole chapter is about. The subdivision control law, we make developers go through the subdivision control law so they're building adequate roadways
So
for
how is
access.
it a subdivision if no lots are being created?
So the A&R exception is an exception to the subdivision control law, and it says that if you submit a plan to the planning board that has adequate frontage on a way for all lots shown on the plan, then that plan does not have to go through the subdivision control law because we are completely comfortable that the lot is big enough, it has enough lot area, and that it has frontage on one of three types of ways. The three types of ways required are either a public way, a way that has been, is on an endorsed and approved subdivision plan, or a way that was in existence before the subdivision control law went into effect. We do not have any of those types of ways here. If you look at the plan, you can see that Meadowbrook's lot has, is a rectangularly shaped lot with Patricia's Path running through it. Patricia's Path does not exist. That was never built.
When you say does not exist, are you talking about as a matter of, fact in the physical world, or are you talking about paperway or some other kind of, does it exist?
I'm talking about everything. It does not exist. It is not there. If you go there, it is not on the ground. There is no.
Okay, so I'm not talking about on the
Yeah,
ground, I'm
yeah.
talking about also on paper. Prior to the preparation of these plans,
Yes.
did it exist in any form, even as a paperway?
So the exact same plan was submitted to the planning board previously.
On the previous subdivision
As
plan,
sub-
right?
correct.
How about before then? Did it exist before then?
On a plan
Or anything else?
Any way that it existed does not meet the requirements of A&R, which is only, you can only grant the A&R endorsement if the lots are on a way, a public way, a way approved, on a approved and endorsed.
No, it's not one of those two. Yep.
And a way that was in existence before the subdivision control law went into effect. We have no evidence of
Right,
that.
but that doesn't mean it's a physical way or a public way, right? It just means that it's a way.
And in order to get the A&R endorsement, you need to have one of those three types of ways. And this plan that they have submitted is misleading because it shows Patricia's
I'm
past.
just trying to find out what in the record shows what did or did not exist at the time the subdivision law came into effect, which was when?
Oh, in the 1940s.
In the 40s. Okay.
Yes.
So is there anything in, this case was on summary judgment, is that right?
That's correct.
Okay, so what in the summary judgment record showed what was or was not in existence in the 40s when the subdivision law came into effect?
There's nothing in the record to
Okay,
show
so
that.
how is that not sort of a fact that we need to know before we know whether or not this falls within one of those three, if your argument depends on it falling within one of those three?
Because that is evidence that would have had to have been given to the planning board. All the planning, endorsing an A&R plan is a very ministerial act, and they look at only the plan that's in front of them, which is this plan. And they need evidence that it's either a public way, so they would check with their own.
Okay, so I think it's undisputed that it's not a public way.
That's right. And a way on a subdivision plan. There was a subdivision plan, but it was withdrawn, so it was never
That
endorsed.
lapsed or whatever, yep.
So the onus wouldn't be on the planning board to prove that this was a way before, that would be on
Okay,
the
so they
applicant.
never, so your position is they never showed to the planning board that they fell within the third category?
Correct.
Okay,
That is correct.
okay. Can we go back to the question of the lot, though?
Yes.
I'd like to know what the town's position is as to what this plan shows. Do you think it's showing no lots, one lot, two lots? What? I couldn't tell from your brief what you were.
So that's the problem, because an A&R plan is supposed to be so clear and so easy to understand that we don't have to go through the subdivision control law. And the applicant throughout the process was making different arguments. At sometimes they were saying there's no lots, sometimes they were saying there's one lot. The city thinks this looks like two lots with the road through it, an argument.
Where's your argument? I'm just trying to find out the town's position.
Yes.
Is it that it's two lots?
Yes.
Okay, so can you tell me, so I can understand what you think the two lots are?
Yes, I would say the top portion, again, I think the
Okay,
town's.
so to the east of the road?
Point to it.
Yes. I can. So this is actually the town's position, and you can read this in the meeting minutes, which I've submitted in the records, is that they couldn't, this wasn't clear. It was not clear to the town. They said sometimes the applicant is saying this is one lot. And then they were saying, well, look, this roadway goes through the middle. So we have this lot up here. We have this lot down here. This is 40,000 square feet. Zoning in Brockton requires 30, so that is a lot. Why isn't that a lot? It's not marked as unbuildable. This one up here is marked as unbuildable. But why isn't this lot on the bottom considered?
What's the total area of the locus?
It's actually more, I don't recall off the top of my head, but it's more than the amount that they have.
Is it 3.53 acres?
That sounds right.
All right. Well, so the plan that you're referring us to says lot area, 3.53 acres, not a buildable lot. Doesn't that make it clear that this 3.53 acre parcel that's shown here is not a buildable lot?
So that brings me back to my argument that there is no lot exception. If we follow that to the end, then what they're saying is this is one lot that's not buildable. Well, I could hand you a piece of paper and say, this piece of paper is blank. So it doesn't have to go through the subdivision control law. You must endorse it.
Okay, so there's if we take this as a representation that there's one lot here, but it's not buildable, how would the purpose of the subdivision control law be frustrated by stamping this A&R?
Because we're saying that this is very misleading. If you stamp this A&R and this is recorded in the registry, anybody looking at this plan is going to see a roadway running through the middle of lots. And they're going to think there is an actual road, and that was actually the whole intention behind this plan.
What more would need to be said than what's said here, which is the total area of the lot in its entirety?
So the problem here is that there is no frontage on a way, because the only way in existence is Westchester Street, which is to the north. There are two parcels adjacent to Westchester Street. That is not Meadowbrook's parcel. That is Judge James Chin's parcel, plot 42-3, and George Reed's parcel 42-1. This land has no frontage. And I know the judge cited several cases about the one-lot exception. And the one-lot exception does exist, but in every single one of those cases cited, as a threshold matter, the court decides that the one lot has frontage on a way. And the case law does have analysis about whether frontage is actual or illusory, but that only comes into play after you've determined you have at least one lot with frontage on a way. In this case, we have no frontage on any ways.
Did you argue to the Superior Court judge that there's no such thing as a no-lot exception?
I did not argue the underlying case, but
Well, did the town argue?
I think they did.
So the portion that's going between Reed's and Chin's property, the portion of the way, is that going to be, that's not part of the parcel here?
No.
That's what, an easement?
Must be an easement. I just really quickly wanted to touch upon the one-lot exception case law, because that is cited in the decision. So the one-lot exception was created in Bloom versus Brookline in 1963. In that particular case, there were two lots. One was a lot, and the other was a sliver parcel. They both had frontage on a way, and the problem was that the sliver was not a lot because it didn't have enough lot area. But the court said the plan could still be approved because there was one lot with frontage on a way. And then later we go to Krakonis versus Bloom, which again is three lots. Two of them are clearly not on the way. They are marked clearly not buildable, no frontage on the way. There is one lot with frontage on the way. It's 20 feet, but they have a variance for that frontage of 20 feet in Drake-it. The next case is Corliss v. Milton.
I think we can go through the case. I have a couple of questions for you. I take it your position is that even, let's say, if the requirements for an A&R are met, that the board has some discretion nonetheless as to whether to grant the A&R or not? Or is it that if the requirements are met, then the board must endorse the A&R?
If the requirements are met, then the board must endorse the A&R.
Okay, that helps me to understand that. And then I have another question, which is that if they get the A&R, is that all that's required to build the road? Or are there other approvals that are required before you can build a road? So I'm trying to find out, what does this A&R really do?
Yes, so this is the whole problem. The subdivision control law is there so that when people develop lots, the subdivision control law also regulates the building of the ways to make sure and grants the town and city the power to have local regulations. So you have to go through the subdivision control law to build a way. And that's the problem. They're putting a way on an A&R plan. That does not make any sense. It needs to be processed. If this was,
How do you get approval to build let's say you just want to build a road to nowhere with nothing on it. You just want to build a road. What do you need to do?
you would go through the subdivision control law. If
You
you wanted
can't-
to do nothing with it, I guess you could build a road on your property, but then you're not going to be
That's
able.
what I'm asking. With no lots, you're just like, I'm just going to start building a road. It's going to connect from a road in this town to a road in another town.
But you're not going to be entitled to an A&R endorsement because that is putting the world on notice. I mean, this plan would be recorded with the Registry of Deeds. And anybody looking at this plan would say, oh, look, there is a way, and I see a couple of lots here. And that's the problem.
Well, but it says 3.53 acres, not a buildable lot. So how is anyone going to be misled into thinking that any land to either side of that way is buildable?
Because the A&R process requires frontage on one of three types of ways, that is required. That's required under the one lot exception. So if you looked at this lot and you knew they got an A&R, you would say this lot has to front on a way, and the only way I see here is Patricia's Path. So you would believe it's misleading. And that's the whole point of A&R. It's supposed to be that the situation is so simple, these lots are already on a way, are not worried about access. This is not simple.
So if the notation not a buildable lot had been placed to the, looking at the plan as it is in the, in your addendum, underneath the road, as well as above the road, would that be sufficient to stamp this A&R?
It would not, because once again, it's misleading. Because anybody who, in an A&R, you need frontage on one of three types of ways.
Well, can you just look in the corner or wherever it says A&R, or don't you have to look at the whole plan? And notice that any parcels of land to one side or another of the way are stamped, are labeled non-buildable.
Well, you would
Otherwise, wouldn't how could you have the Bloom exception?
I just think.
If you can't rely on the notation on the plan that it's not a buildable lot. Aren't people presumed to look at that, not just the A&R endorsement, and say, oh, I think I know what an A&R means?
Well, this plan did not say that. I mean, this plan does not say that bottom lot is unbuildable. So that didn't happen. And even if it had happened, the A&R plans are not supposed to be confusing. It's supposed to be such a simple situation that we're not going to make people go through the subdivision control law.
Okay, so if they,
Go ahead, follow up. Can a lot be not buildable for something other than not being on a way?
Yes. If it has wetlands or there's some reasons, yes.
So to follow up on Judge Sachs's question, if we moved where it says 3.53 acres not buildable down so that it's up against Patricia's Path, even though it says not buildable, would I know why it's not buildable? Would I still believe that it's on a way and maybe not buildable for some other reason? You follow that?
I'm sorry, I'm not following it, but try again.
So if we moved from where it says not buildable.
Yes.
And we move that down below over here.
Yes.
So now it's right up against Patricia's Path.
Yes.
And it still says not buildable. Would I infer from that Patricia's Path is not a way? And that's why it's not buildable? Would I have any reason, would I know why it's not buildable?
No, you wouldn't know that because it could be a multitude of reasons. Correct. Yes, it could be a multitude of reasons.
I think unless there are questions.
Oh, yeah.
Then we're going to have to leave it there. Your time has expired.
Okay, thank you very much.
Now, hold on. Let me see if there are any questions for you. Do you have any questions for it? No. All right. So we're going to leave it there. I don't think the panel has any questions for you. So we're going to leave things there, and the case is submitted. Thank you very much. The next case is 2022 P 1185 Fort Point Investments. sorry, there's... All right. I wanted to wait for that sound to settle down. 2022 P 1185, Fort Point Investments versus Hope KIRUNGE-SMITH. The case is partially impounded, so everybody needs to be sensitive and not disclose the impounded information here in open court. And is it Attorney Loomis?
Yes, Your Honor.
All right. So we are ready for your argument whenever you are ready. Just adjust the microphone and remember to speak up, please.
Your Honor, and may it please the court, Fort Point Investments took more than $25,000 in taxpayer money upon the condition that they would dismiss the pending eviction action and reinstate my client's tenancy. They did neither. Fort Point Investments, while negotiating for the second half of that RAF payment, also ignored.
Is there any evidence in the record of the landlord's actual receipt of any contracts or other documents setting forth the terms of accepting raft assistance that you just referred to?
Yes, Your Honor. Addendum 90 to 91 contains the DHCD letter, which says that this goes to every landlord.
Is there, okay, but can we take judicial notice of the truth of that statement?
So I believe this court can, Your Honor, but I would also emphasize as well that the landlord has not denied that it received the terms of these contracts either on appeal or below. And I would also point out that this is part of the reason why the Berube analysis requires only a sufficiently meritorious claim that's worthy of further investigation.
All right, well, you asked us to resolve the merits of the raft defense, but if we have a doubt about whether the landlord received, whether it's this letter or something else that describes the asserted terms of the raft agreement, then we shouldn't resolve that defense, should we?
If this court has a doubt whether or not they actually received the terms that agreed, this court should not resolve that right now. However, I think that this court doesn't need to have those doubts, but I'm not disputing the overall point, Your Honor.
Okay, so other than the DHCD letter that says we send this to everyone, there's nothing that shows the landlord received this?
Well, Your Honor, we're not entitled to discovery on a Rule 60B motion.
I understand that you don't have the discovery. I just want to make sure there's nothing in the record currently.
Correct, Your Honor. And
okay.
If I could just say as a general rule of principle, part of the RAF payment here was issued after the entry of judgment in this case. And one of the benefits of the RAF program is that you could have payments go out after judgment has entered to prevent imminent homelessness from occurring. So it's worthwhile, I think, to allow a tenant to submit a Rule 60 motion in circumstances like this, even if they don't have concrete proof that they actually ever received it. Otherwise, it would be impossible to get RAF relief after default judgment entered, and that wouldn't be a good rule to create going forward. But beyond the second RAF payment issue, Your Honor...
Could I ask about the third Berube factor?
Of course.
Which is whether the neglect occurred before trial as opposed to during or after trial. Which way does that factor cut? In other words, if the neglect occurred before trial, does that cut in favor of allowing the 60B1 or against?
I think if it occurred before trial, it would probably cut more in favor of granting the Rule 60B1 because it's just earlier in the case and earlier to fix things. But I don't think that that's a particularly strong factor in the court's analysis. And I would emphasize as well that, this occurred before trial, but it also occurred with all the case initiating documents. And also that Rule 60B, the Berube analysis, when they refer to the before or after trial, it was in the context of ordinary civil proceedings where you often have very long, extended proceedings, not a summary process proceeding where everything will be truncated, which is another reason to keep that factor somewhat discounted. I would submit further that all of the other Berube factors strongly support granting the Rule 60 relief here, and the court abused its discretion both by failing to apply Berube, the proper legal standard, and by improperly imposing a deadline ex post facto on my clients to submit a Rule 60B motion when there never was a deadline, and disregarding the fact that my clients explained why they had failed to file their Rule 60B motion earlier. Through March, when my clients were negotiating to obtain a second RAF payment to try to clear their balance with the landlord, and the housing court judge excused the landlord for missing the mandatory deadline for obtaining a writ of execution based on those negotiations. So my clients didn't have any reason to know that they were still at risk of eviction until they sought the second motion for eviction, for a writ of execution, in March of that year. And at that point, my clients then spent several months trying to obtain the initial RAF papers. And of course, they weren't able to obtain proof that the landlord actually received the actual documents itself saying that.
Where does the record support that once they received the motion for the reissuance of the execution, they started to try to obtain the RAF papers? Is that somewhere in the 60B1?
It is, Your Honor, and it is on page. Your Honor, I'll give you the citation in a moment, but that is actually stated explicitly, and it's also flagged in both our opening and reply brief that the reason why they didn't file a motion earlier was because they were trying to obtain the RAF papers. So that was another reason for their delay.
So they defaulted a couple of times by failing to show up for trial, right?
Well, Your Honor, with apologies, they defaulted once. They were there in the July trial date, but the court granted a continuance, and that's reflected in the docket order.
Okay. And the court seems to take some issue with the lack of medical documentation to support the allegations of the quadruple, I might be mistaken if I say quadruple, but the heart attack and the extreme medical challenges that prevented them from appearing.
So, Your Honor, to be clear, for the second trial, they said that they were experiencing severe medical illness and like heart pains in the 2 days leading up to trial. That's not something that would necessarily appear on a medical document because they didn't go to the hospital to receive treatment for it. So this case is actually very much like the Hannah M.M. case that we cite out of the New York Appellate Division, where evidence of the fact that they had suffered previous heart attack was taken along with a statement from the clients that they had experienced heart problems the day before the trial. That was considered to be sufficient evidence and sufficient grounds to default.
Well, it seems here that the court's a little bit suspicious of that, and so why not, if you have the documents, why not submit them? I mean, they waited to get the RAF stuff. They were able to diligently pursue that and come up with that. It seems like this documentation would be a little bit simpler to obtain, and yet it's absent in the record.
So, Your Honor, if I might just unpack that for a moment. So, the court didn't say in its original Rule 60B order that it didn't believe that they ever had a heart attack. That's not what the argument was. The court, in its most initial ruling, which I can address why I thought that was improper, stated that he thought the medical records did not prove that they were in the hospital or so the day or two before trial. But the court's initial ruling doesn't doubt that they had a heart attack, and they actually did submit some excerpts of record that refer to a cardiac surgery that was appended to the Rule 60B order. And then before the court was able to assemble the record, we did submit further medical records that refer to the actual surgery that took place and refer as well to various treatments they got, and that even on the 2 days before trial that Mr. Goldman was wearing a life vest to basically an automatic defibrillator that would go off because he was so at risk of sudden cardiac arrest. So I think that because there wasn't a credibility determination, and this is not a ruling that would be entitled to deference, it's something that the court simply overlooked as to why they failed to appear for trial. And then the final issue was the RAF payment, which I think, again, is sufficiently meritorious of investigation that it's worth litigating. And I'd also emphasize as well, and I think this is quite clear from the record, that Fort Point admits on page 103 of the appendix that if they in fact had received the full balance of the RAF payment, that they would have been required to dismiss the case. That's not disputed by Fort Point in this case. It's not disputed by the housing court below, even setting aside the receipt of conditions. That's a very important point here because the RAF payment was undisputedly several $1,000s more than the rent that was originally sought in the notice to quit, and it was also several $1,000s more than the rent and utilities as well. And the only reason it didn't fully clear out the balance was because they also impermissibly sought storage and parking fees.
We don't have the ledger past December 1 of '01, I think, and we only have one entry on that day. So are we really in a position to calculate whether the arrears were fully covered?
So
I understand your point that, parking and storage, it's arguable whether they're covered by RAFT or whether the non-payment of those fees can be a basis for a summary process action. But can we really evaluate the financial picture here without?
So, Justice Sachs, pages 227 to 29 contains the ledger from early 2020 through December 2021. And so you are able to evaluate and add up those numbers. And I added them up for you in my brief, but you can check my math. And it does confirm that the balance should have dropped to below zero for both rent and rent plus utilities. very much in early 2021. This won't tell you whether or not the balance would have dropped to below zero in spring 2022 when they received the second RAF payment, but that's not the argument I'm making. I'm making the argument that they were required to dismiss the case before judgment entered there.
So I had a question about the ledger. I take it that we don't have the lease or the lease in the record? Or do
So we submitted the part of the lease that refers to storage and parking fees in our appendix, but we didn't submit everything else.
My question is because some of these charges appear to be pass-through charges, pass-through for electricity, gas, water, and I'm wondering how we're supposed to know whether the failure to pay those is an event that could result in eviction, or and also whether RAFT is applied to those or can be applied to those, and if it is, what effect that has, or do you see what I'm saying?
Of course, Your Honor.
So I didn't see that addressed by anybody.
So Your Honor, that's because if we put forward two calculations in our brief. The first is if you only include rent and not the pass-throughs. In that case, RAFT greatly exceeds it. If the second case, if you take into account RAFT plus the pass-throughs, which I think was allowed by the lease to be charged as rent, and even if you take all of that into account, RAFT still exceeds this by several $1,000s. So this court doesn't need to resolve this because it's...
As of which date?
As of the first RAFT payment in April 2021.
Okay, so the only way that it doesn't satisfy the complete arrearage as of the date the payment is made, in your view, is if one includes the parking and the storage fees.
That's correct, Your Honor. Now, I'd like to turn briefly to the Section 23 issue as well, because I think it's quite clear that the Section 23 deadline for obtaining a writ of execution on a judgment...
So, I'm sorry. So can we just go back to that?
Of course.
So when we're to try to determine, let's assume that we all agree, or we agree, that if you receive full reimbursement under RAFT, then the case has to be dismissed. The question becomes, did you receive full reimbursement? And what's the best authority for what needs to be reimbursed?
Well, in this case, the lease would provide that clear authority.
Okay, so we don't have a full copy of the lease.
Well, so Your Honor, we submitted the part of the lease that was relevant to this issue, and the lease says, the part that we did submit says that that storage and parking fees cannot serve as a basis for eviction.
Where is it?
I think it's 52. One moment, Your Honor.
The addendum to the lease.
Appendix 50, page 52, Your Honor. And to be clear, Your Honor, if there's a concern about completeness here, I would be happy to resubmit the pages, but it's all part of the record and was part of the record below attached.
It's very difficult to read this. In the event that residence apartment, something included in the community's affordable housing program, if any, something additional required payment for the checked areas, something of paragraph 1 are required to be paid at the same time as monthly rent. Failure to pay shall be a breach of this addendum and subject something, the use of the checked areas, but shall not be considered additional rent pursuant to program guidelines. I don't see that it said you can't be evicted for it.
It says it can't be, that the only remedy is loss of the storage space and parking space, and that it can't be considered as rent that's chargeable, that's on the basis of an eviction action.
Wait, you're going to have to point that out to me. I'm looking.
This is all part of paragraph 13, you're saying?
Yes, Your Honor.
I need to see that specific language, please.
In the event that residence apartment is included in the affordable housing program, An additional required payment for the checked amounts of paragraph 4 are required to be paid at the same time as monthly rent. Failure to pay shall be a breach of this addendum and subject to revocation of the use of the checked areas, but shall not be considered additional rent pursuant to program guidelines. So it provides a clear, explicit remedy for loss of this, and then it says that it's not considered rent.
But it says for program guidelines, not for purposes of Chapter 239.
It doesn't say for purposes of Chapter 239, but to be clear, Your Honor, this was also only an eviction action, as stated in the notice to quit, to evict on the basis of withheld rent, not on the basis of storage and parking fees. And if you look at the notice to quit and the complaint, it only lists the actual amount of rent due. It does not mention storage and parking fees. But I would also emphasize
Does it not include, and this is what was throwing me off, you kept saying that it says it shall not be a basis for eviction, and that language is not included there.
So, Your Honor, I think that's the clear implication from the statement that this is that the sole remedy is loss of those spaces, and then it says that
Does the word sole, where's the word sole?
It doesn't use the word sole, Your Honor. It says the remedy for this is loss of the space, and it is not rent. Whereas, by contrast, as the lease elsewhere states, and I'm happy to, this is in the full record, it's not in the appendix, that failure to pay utilities can be charged as rent. And I don't think there's any part of the summary process statute that allows you to evict for failing to pay storage and parking fees.
Was the entire lease part of the record before the judge below?
Yes, it was, Your Honor. And I didn't submit it because I was trying to keep the appendix streamlined, and I didn't think those other parts of the lease were relevant to my argument. I see that I'm out of time, but there were two other issues that I'm happy to address further.
Let me see if there are questions, yeah.
So you submitted a letter regarding the raft payments that said, I think it was directed to Judge Munivar in the housing court. That said, if you accept the raft funds, I guess it was for the landlords, if you accept the raft funds, it would be a violation, I don't have it right here in front of me, to move forward on the eviction, essentially, right?
Yes.
Okay. We don't have any evidence that that letter was sent to this landlord, do we?
That letter was not sent to this landlord,
Or
no.
a letter like that was sent to the landlord?
No, it was not.
Okay. And let's assume, for the sake of discussion, it was, and they moved forward with the eviction. Wouldn't Raft be the ones who would have the action?
No, Your Honor, because I think that the tenants would be considered the intended beneficiaries of any program, the main purpose of which is to prevent homelessness under any agreement. And I think that it makes more sense to, as a rule, to say that tenants are the ones who can protect this by asserting it as a defense in every proceeding, rather than requiring DHCD to appear in every case. I'd also point out that DHCD issued this opinion letter in the case involving Judge Munivar, but DHCD did not file an appearance to dismiss the case. This isn't an issue of standing where we'd have that concern. Your Honor, I see that I'm out of time. There's, of course, other issues in the case. I'm very happy to answer any questions about them. I do believe as well that the writ of execution is an independent basis to reverse, but if this court has no questions, then I'm happy to rest on my briefs.
I think that's where we're going to leave it, given the time.
Thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Eleftherios Papadopoulos, and I represent the appellee landlord in the subject summary process action.
Don't you think we need to have the full lease?
Excuse me, Your Honor, do we need to have the full lease?
Don't you think we need to have the full lease here to understand what's going on?
Your Honor, the full lease would identify the fact that the monthly rent was an agreed upon amount, and it would also reference other sections that any other amount is considered additional rent. Now, my brother does point out the fact that in that addendum, it does indicate that notwithstanding any other language in the lease, that it would not constitute rent to the extent that the affordable program warrants that type of reading. This particular apartment happens to be in the inclusionary zoning ordinance for the City of Cambridge. So whether that actually is a fact or not, that provision, the addendum, is applicable is a question of fact that was never addressed. The important part that I think the court needs to pay attention to is that my brother has pointed to the ledger, and it's important because there's a lot of hidden meanings that you can find in the ledger. So the payment that was provided in the ledger is $13,633.79. That was received in May of 2021. Now, if you stopped looking there and didn't really look to try and uncover anything more, you might say, wow, that's quite in excess of what was due according to the summary process complaint. But if you take a look back on page 228 of the record appendix, $13,633.79 is the exact amount that was due in February of 2021. The reason that's extremely important is because Chapter 257 did not repeal Chapter 186, Section 11, which says that in order to cure a non-payment of rent case, you must pay all rent then due plus interest and costs. So the ability to cure a non-payment of rent case still rests within 186, Section 11. So that amount that was received in May.
But why doesn't the RAFT program modify that to some degree?
Modify what, Your Honor? The statute?
Yes, because it's, you essentially waive, by accepting it, the landlord waives, let's say, the accrual of interest.
Your Honor, I would say that I don't know that RAFT has the ability to repeal 186 Section 11.
No, but the landlord has the landlord has the ability, if it wants the money, to waive certain rights it might otherwise have.
Sure, Your Honor. But again, accepting money, if you look at 239 Section 3, also post-judgment, does not in any way, shape, or form impact the landlord's ability to proceed to the extent that the balance has not been fully cured.
So that takes us back to whether it's been fully cured.
Correct.
So, and I take it that part of that may depend on whether the storage unit and the parking can be included for these purposes.
Correct, Your Honor.
So what's your best case that they could be, that, let's just say that the tenant had paid the rent every month, never paid the storage fee, never paid the parking fee. Is it your position the landlord could evict the tenants in those circumstances?
Absolutely, Your Honor. So a material violation of the lease, yes, my brother is correct, may be found under a separate provision.
Evict for non-payment.
For non-payment of rent, Your Honor, to the extent that the lease, which it does, encompass any and all charges as being additional rent,
How do we know? We don't have the lease.
I understand, Your Honor. So this particular case, Your Honor, and you need to read again, there's a lot of reading between the lines in the transcript. Judge Malamut was actually party, or the presiding judge, in a 2019 case involving the same parties. And in the 2019 case where Ms. KIRUNGE-SMITH was represented by counsel, there was a stipulation that was filed in that agreement. It's a matter of public record. It's a matter of judicial notice that can be taken. In that agreement, she agreed, not only would she sign a lease, but that these additional amounts would be something that she is responsible for, the storage fees, and that she would be responsible for water sewer charges. The lease does provide that this is additional rent. So to answer your question as directly as I can, Your Honor, Judge Malamut was well aware, and yes, the record, as my brother indicated, did include a copy of the lease, and Judge Malamut, in the transcript, references not only the 2019 case, but indicates that you never fully zeroed your balance. And that's an important statement, and why I brought the court's attention to the ledger, which is DHCD was issuing a payment, I'm sorry, the administering agency for DHCD, was issuing a payment for a point in time, and that point in time was February. So if you're going to accept that payment does not resolve 186 Section 11 or 239 Section 3. The landlord was never made whole. What DHCD also says in their letter, and it's actually in the amicus provided by Attorney Feldman, is that there's language that says that the parties shall either dismiss the balance or enter into an agreement for the amount thereafter. There was never any further payment by Ms. KIRUNGE-SMITH or Mr. Goldman to zero their balance. My client worked with them, and this is a matter of no good deed going unpunished. That by working with them, by delaying, by trying to get it zeroed, we've essentially been made to say that DHCD now applies. This contract of adhesion, which is not a contract, there is no signature, which is interesting because my brother raises statute of fraud arguments in their argument. How is it that statute of frauds applies in one instance, but not the other? How is it that my client, not signing any document with the DHCD, is bound by those terms?
What part of the statute of frauds applies to this?
I believe it's subsection 4, Your Honor, that talks about interest in land or the transfer of interest in land.
But there's
And
no
my brother-
interest in land that's
My
at
brother
issue.
has cited case law, Your Honor, and it is at least a belief amongst a lot of the practitioners and even the housing court that a lease for an apartment is something that would constitute a transfer of interest in land.
Okay, but you're talking about the raft payment. The
Correct, Your
raft payment is not an interest in land.
No, it's not, Your Honor.
Okay, so
But-
how does the statute of frauds apply to the accepting the raft payment?
Because if you're discharging a case that allows you to recover possession, Your Honor, it is dismissing your interest in that land. You're entitled to recovery of possession as a landlord. So it's the same argument that the defendant is trying to make on we didn't sign anything to extinguish our rights of possession. In that agreement that Judge Malamut, after 4 hours of negotiation and discussion amongst the parties in open court, are trying to undo. So you're undoing that because, yes, we have an interest in land, the lease, that says that we have satisfied the statute of frauds and we have a tenancy. That tenancy was terminated. A notice to quit extinguishes those rights. It's then the court's position to make a determination as to whether the landlord is entitled to recovery of possession. We did recover possession. We recovered possession in August of 2021. And this was after, as Justice Desmond identified.
You mean you got a judgment for possession, right? You didn't actually recover possession. That relies on levying on an execution, which hasn't happened.
Correct. So, and I think there are terms of art. Yes, we had a judgment, Your Honor. We had an execution for possession. Possession, for all intents and purposes, legally was in my client's hand. They did not have physical possession. And physical possession would be after levying on the execution for possession.
Can you turn to the argument about the reissuance of the execution?
Absolutely, Your Honor.
And its timeliness?
Yes, Your Honor. So I think my brother identifies the correct case as well that identifies what the court's authority and court's position is in terms of reissuance of an execution. So it is under the Bernier case, and I apologize, Your Honor, for the delay there. But under the Bernier case, you have sections 23, section 17, and section 19 that flow with one another. And that case actually stands for the proposition that, yes, they can all exist harmoniously. And the way that they exist is that under 17, it would be a situation where the original execution may be reissued. In section 19, it would be that there was no issuance of an execution, an original execution, and the court then, by motion, has the ability to issue that execution. That's what happened in this case, regardless of which way you cut it.
What was the defect?
The defect, Your Honor, and I do apologize that it's not in our brief as an actual copy for the court. An execution for possession has a specific section in the middle of an execution that says premises. And that's the premises that you've recovered possession for. It's blank. It's absolutely blank. So a constable who receives that execution and is trying to levy says, I don't even know what address to go in unless I go to the court's docket and find it, et cetera. It's an argument that that execution is not valid.
All right, so that defect was discovered during the 3-month period for issuance of the execution. Never mind the 3-month period for levying once the execution is issued.
Yeah.
Wouldn't a sensible interpretation of 235-23 require at least that once the defect is discovered, particularly if it's within that 3-month period, the landlord come back promptly to the court to get it corrected? And here the landlord waited another 6 months, I think.
Your Honor, the defect was discovered in about November.
Maybe 4 months, I'm sorry, before.
Right. So the defect was discovered in about November. And the request was made directly to the client to return that execution because the court will not reissue an execution or even entertain that motion.
So it was lost in the mail, I gather?
Excuse me, Your Honor?
It was lost in the mail for a while?
Exactly, and that's in the record as well.
So that would be excusable neglect in a way?
Correct, Your Honor. And aside from being
Would
excusable...
that be like the tenant's excusable neglect in delaying filing their, or in being defaulted or not filing their 60B in time?
I don't know that it is, Your Honor. And again, the argument would be, and Judge Malamet actually articulated it several times, not only during the hearings, but the excusable neglect was the court, the housing court, for those of you that may not have practiced in there, we're there daily, is a very compassionate court. And despite belief, provides several bites at the apple. So this original request, so first of all, there was a Tier 1 mediation that I know Judge Desmond referenced that she did not appear at. A default does not enter at the Tier 1 event. A scheduled trial date was created at that point on July 1st that she then asked to continue. So when we talk about excusable neglect, Your Honor, we're not talking about you discovered it and filed it late. We did file it.
And she says that she tried to file things in August and was on the phone with the clerk, and why haven't you received them? And the clerk says, you'll get a notice, and then she doesn't, and then lo and behold, she's defaulted.
Yes, Your Honor, and the transcripts, if you read page for page,
second trial date,
is littered with her making statements about, I did this, was told this, and didn't get anything. So she also essentially points the finger at the court on several occasions, says she didn't receive the original notice of hearing to appear on the trial, the date, the original date, and the subsequent date, claims that mail was returned. The court has no record of mail being returned. And during the transcript...
Is that in the record?
It is,
the
Your
court
Honor.
has no record?
It is, Your Honor. Judge Malamet actually makes that reference in the transcript, saying that we have no record of any mail being returned. And that's a red flag for the housing court. Whenever they see a red flag, and the reason why we have the new standing order under Chief Justice Horan is because the first-tier event must now be served by the landlord on the tenant to ensure receipt, so that these issues of default don't occur and create a procedural issue where the tenant should be entitled to the merits of their case.
Can we go back to Section 23? Because what I'm trying to figure out what your argument is with respect to that, because everything in there is mandatory, not discretionary. It's all shall, all the deadlines. So help me understand how Section 23 helps you with respect to the reissuance of the execution.
So
it says, shall be issued. Sorry, I'm looking at it. Shall be made returnable within 3 months of the date of issuance, and shall state the date of issuance. There doesn't seem to be any carve-outs here.
Your Honor, the argument could also be, and this is why it's a bit of a circular argument, that the execution did issue within 90 days of the judgment. Unfortunately, it was defective. It didn't have the premises on there. The execution did have a 90-day expiration period. Unfortunately, the execution was defective. So if we're reading the statute and saying that this is what it says, you could argue that there was compliance. But the argument that we're making, Your Honor, is that if legislature intended for this execution, for possession, to never reissue, 4 words could have accomplished that. And I don't think it's this court's position to do it, nor any court's position to do it, which is those 4 words could simply be, it shall thereafter not reissue. But that's not the case. And 17 and 19 provide that catch-all that I've already relayed to the court.
Well, the second paragraph refers to executions, not original executions, alias executions, any other kind of execution. It says executions shall not issue later than 3 months following the date of judgment.
Right. And again, I would go back to the original.
How is that different from the 4 words that you said were missing?
Because the original execution did issue in this case, Your Honor. It did issue. So there was, if you want to call it, compliance with this statute.
Okay.
The issue that my brother brings up.
And then there has to be levy on that execution within 90 days of issuance, or 3 months.
A levy could not occur on that. It could not occur. It could not occur on that execution.
So where the purpose of the statute seems to be frustrated by an error on the part of the housing court, why perhaps they have authority to reissue it if the landlord comes back promptly and says, hey, this execution is defective.
Correct.
In essence, you never issued an execution.
Correct, Your Honor. And the additional argument that I'd like to make is that my brother points out that we continue to try and work with the defendant to try and get her the payment. Our clients are in the business of providing housing. They are not in the business of trying to evict. So yes, after the motion was filed, and during the motion being filed, and pending hearing, we were working with her to try and get her to potentially file another raft application and to pay any other deficiency. She never did. And this case is one where, in addition to what remains outstanding today, which is unpaid rent that Judge Malamet identifies, is about $10,000 in outstanding amounts. So the equities have never been in the tenant's favor. And there are procedural issues that we think are important for the court to note in terms of the single justice determination in this case. But again, I know that becomes another complicated layer to this onion, Your Honors, where the judge invited Judge Malamet, Judge Hirschfang invited Judge Malamet to reconsider whether sua sponte or by motion of either party the issue of the Rule 60 dismissal. Or vacating of the default judgment. Judge Malamet did that, and the transcript, the docket would support that. He actually invited the parties, and in September of 2022, there were motions.
I read the single justice order as saying, well, because the appeal hasn't been docketed here yet, and that left a several-month period, and then the appeal was docketed here, and Judge Malamet's memo, which you attached to your 16L letter, was issued a year, well, 10 months after the appeal was docketed here.
Well, and the reason I bring that up, Your Honor, is because he had done exactly what the court directed within the time frame before the docketing of the appeal. So there were pending motions and pending hearings and additional evidence taken on why, in fact, the defendant was not at court on the original hearing date or the subsequent hearing date, or why no motions were filed. Documents were provided that are not part of this record, and Judge Malamet issued a subsequent final order essentially reaffirming his decision. But I would argue, Your Honors, and this is the last point that I wanted to make, is that at various...
You're out of time, so
I apologize.
I'm going to just see if there are any further questions. Okay. Did you look at this? Okay. No, okay, so there are no further questions, so we have your briefs. The issues have been very well presented, both in court and in the papers, and we're going to have to leave it there.
Thank you, Your Honors.
Thank you. With that, that concludes our sitting for today, and we are in recess.
All right, please.